All right, can everybody hear me?
I can hear you.
Yeah, can you hear me?
Yes, I can.
Much to your chagrin, can you hear
Yes,
me?
that's correct. I wish I couldn't, but I can.
You poor thing.
This is 20-9583-DM. It's Small Wilson versus Wilson. The plaintiff, Ms. Wilson, is represented by Nick Masad. The defendant is unrepresented. This is father's objection to the income withholding from the friend of the court. The friend of the court, I understand, is currently involved in a child support review that was asked for as of like 11/14. Isn't that correct, Mr. Wilson?
Yes, I opted into a friend of the court services. So before that review was over, they garnished $977 about for the last 4 pay cycles, about $3,900. So the data that they used to arrive at that garnishment was from like our original divorce. When we turned it in, we had a mediator. So when
They're not gonna go back on it. They're only gonna start once you ask for, as of 11 or 11/14 or something. They're not gonna do retroactive modification.
Right, so we've been 50-50 since August 22, 2021. So that's they're garnishing based on me having like one night or something, and it was like way back in 2020. So it's been years and years we've been 50-50, and I have the our mediation document that confirms that.
But was that the amount that was owed from years and years?
No,
Yes, that was
Mr.
their original uniform support order, is what they're taking. When he opted in to get the support review, it triggered them to then begin to collect on the original uniform child support order. There was never a modified order filed with the friend of the court or a modified uniform child support order. So I guess technically, for this court to do anything with this motion, he would have had to file a motion to modify the support with some form of calculations indicating that the amount that they are currently withholding is inaccurate. What he did was he filed a motion basically to suspend the IWO in this case, which you can't do. I mean, there's a support review pending. Once that recommendation comes in, it'll be effective whatever date was that the request was made. And if there's overpayment, that can be addressed by the front of the court on their sliding scale. Or if there's an underpayment and there's an arrearage, that also will be addressed on the sliding scale. I don't think the court can give him the relief he's asking for, but again.
Well, I might be able to, but I'm not inclined to, because I'm letting the friend of the court figure everything out, and then I'm gonna figure it out. Okay, I mean, that's what it comes. I assume that if this is, you're basically 2 months into the review, have you been contacted by the friend of the court? Have you provided all your income information and stuff?
Yeah, everything's been sent in by both parties.
All right,
We're waiting.
we'll get a report here fairly soon and see what happens. I'm not gonna mess with the friend of the court until that happens, and when it happens, you'll be able to come in and say, hey, look, I paid $3,000 and she now owes me $2,500, and we'll deal with it at that time, or vice versa. I just don't know. I have no idea what the incomes are or who has what, and I don't have anything in front of me to say what the child support might be supposed to be. Friend of the court's dealing with it, and the friend of the court has a lot of expertise in it. All I'm doing is denying, because you just don't want a withholding order. I'm not gonna do that. I'm just gonna wait and see what transpires from the friend of the court. We'll get it and we'll see what happens. I'll deal with it at that time. If you're owed money, to get money back. What?
You want me to prepare an order?
What?
You want me to prepare an
Yeah,
order?
yeah, all it is a simple denial, of the, motion, but certainly gonna wait and see what happens based on the friend of the court order.
All right, appreciate it. Thank you.
Your Honor, can I comment, please?
Can you what?
Can I comment, please?
Why, you think you're gonna change my mind?
I don't know about that, but so this garnishment is based on incorrect facts. I appreciate, so like when we got our divorce and we submitted it, That's what's on record, so I appreciate that. We opted out of friend of the court, and then basically I paid, you know, Shannon,
And then you opted back in and the friend of the
and-
court. See, all you're doing is the friend of the court works a certain way and I'm letting them work their certain way. All right, when you opted back in, I don't know what the numbers are gonna be, so I'm denying the request right now. And it'll be fixed probably by February, I'm sure. I'm sure they'll have something out and you guys will figure it out and then figure it out from there, but you're not gonna change my mind right now. Sorry. Good luck.
Thank you.
Thank you. Good morning, Mr. Vanden Heuvel. The plaintiff has never logged on. I'm sure you didn't even give her notice. Is that right?
That's right. No, we did actually. We were just going over, I just checked my proof of service. She's been notified. In fact, she communicated that was in the notice too, in the motion that she would, she was just not gonna do anything to keep this child.
Okay, well, we kind of
More important.
waited a little bit to give people chances to get on. She is not, I don't think she's ever been on, has she? All right, this is case 14-9242-DS, Soria versus Estrada. The plaintiff has never logged on. Mr. Estrada has, and he's here with his attorney, Mr. Howard Vanden Heuvel. This is a motion for custody. My problem is she's never logged on, and there are a lot of allegations. The mom is drinking, doing drugs, leaving the child alone from 3:45 to 8. There's domestic violence in her relationship with her boyfriend. An ex parte was obtained by the defendant through the judge on 10/3/24, and allowed for parenting time for the mother to visit supervised at Journeys. And she basically sent a text message, says, I'm fed up and I'm done with this. I don't know if I kind of summarized what you said.
Yes,
Anything you want to add? Yeah, you clearly meet Vidvarka, all right? And you know I can't just change custody on a Friday morning. I will maintain the ex parte order and we'll set it up for a custody hearing, because Mr. Vanden Heuvel, you know I have to do that.
Mhm.
So anything you would like to add?
I guess we are at, and the relief we asked in the complaint, we asked as a matter of making a permanent temporary order pending that there would be, you know, either it could be supervised through Journeys, or if she wants to engage SoberLink and show sobriety for a period of month, then maybe, you know.
You know, you're always able to modify it, but basically, as far as a permanent temporary order, that's your attempt to permanently change. Look at it, looks like it's a slam dunk, all right? I'm just telling you here, all right?
Yeah,
It
thank
looks
you.
like it. But, you know, the Court of Appeals says I have to have some type of an evidentiary hearing. I mean, if she wants to agree to it, it's fine, and I have no problem with making that ex parte order continue until that time where she can have visits at Journeys, okay? Now, you can always agree if you want something else to do that. I mean, I'm not gonna be there, and if you say, hey, look, if you're in SoberLink and you wanna take the child for the afternoon, you can do that, but I think the order that I would maintain is just similar to what the judge ordered in the ex parte, that she can have parenting time at Journeys should she decide to do that.
Okay,
And
And-
until then, and we'll get you I'm gonna get you a kind of quick hearing date, all right? Because I'm only gonna schedule it for like an hour. All right, which is an incredibly short amount of time for a custody hearing, but at the rate it's going, I don't see that she's gonna probably do anything. If it requires more, we'll deal with it then. But you could come in, we'll have it in court and you can come in and put on brief testimony and I can make my findings right then and there. And
okay,
possibly do it. I know it sounds, sir, like I'm making you jump through hoops, but it's what I believe the court has to do. And normally I would set this for a minimum of 3 hours and you'd be out in till April, till you got a hearing. I'm gonna see if we can schedule you, and Mr. Vanden Heuvel, my clerk, will be in touch with you, but.
Okay. All right. So I have my calendar out otherwise.
You have-
Okay,
You have do you have the 29th at what time?
10:30.
10:30 till noon?
Yeah.
The April, or I mean, this month, 29th, 10:30 till noon?
yeah, I could do 10:30 till noon, Your Honor.
Geez, oh, Pete, that's awful accommodating.
That's
I
very,
can't believe we,
Anything.
don't say that. She said anything for Howard, and I said, don't ever say that, because then that gives him a big head, and we don't like that, okay? Since when is he on your list of good people, all right? All right,
All right.
Mr. Estrada, I hope you can, I mean, you gotta be here. And we will see what we can do. If she shows up and fights or all this kind of stuff, whatever, I will send you, Mr. Vanden Heuvel, a notice like I send everybody regarding witnesses and things. I want to tell you that with her lack of participation in anything like that, I'm assuming that at this hearing, you would probably just have your client testify. For
Yeah.
So, and you can do it. As far as a trial brief, just, I'm just gonna assume that the motion that you sent in can act as your trial brief. All right,
Okay, thank you. Your
I'm
Honor.
just trying to save your client some money and some time and stuff like that too. All right,
Yep, I know my client much appreciates that.
I mean, yeah, you can send in the briefest thing and say, only so you comply, all right? But just, saying we rely on that, and at this point, only witness will be Mr. All right, I don't want you to completely ignore my order, but you know what I'm saying.
I do, I understand fully, and if anything different happens, I'm sure we can deal with it then. We'll,
Yes, if you get something, everything's gonna fall apart and she's got an attorney now and all this kind of stuff, call my clerk and let's see what we can do, all right?
We'll do that, and
Good
then
luck.
one
Pardon?
matter he is still, he mentioned to me, he's had the child full-time since October 3rd.
Yeah.
Just several months ago. He is being booked for $396 a month of support. Should
We'll
we
suspend that.
Okay, thank you.
I'll suspend that. We'll deal with it later, okay, but as of today, we'll suspend any further child support.
Okay, perfect. Thank you, Your Honor.
Anything else I can do for you?
No, I think that pretty well does
Sure.
it.
You want me to order lunch? It's been a while since I've seen you, Mr. Vanden Heuvel, and I always have fun with you, so thank you for being a good sport.
One of these days on lunch. There you go. All right.
Good luck. Take care.
Thank you very much.
Thank you. You'll draft the order.
I'll draft it.
Thank you.
You're welcome.
Thank
Take
you.
care.
Thank you. This is a motion that has been filed by the father regarding custody. He says mom has medical issues and wants to stop her parenting time altogether.
Actually, Your Honor, I'm sorry for interrupting. Actually, the paperwork got mixed up when I was at Legal Assistance Center. It is about parenting time, but the motion was supposed to be set. We had a disagreement about our holidays. And we both agreed that the holidays would be every other holiday. And when I went down helping her out, because I know she doesn't have a lot of money for gas, to drive back and forth. And when we were in front of Judge Hillary the last time for a motion, he told her that she needed to drive back and forth. So I said, I'll do this for her because I know she was working. I'll go down and pick up my kids because technically she had the kids for Christmas and New Year's would have been my holiday.
Okay, so what are you asking for then?
So I'm asking, both of us talked about it. We're asking that it be written and signed by a judge that we are supposed to be in agreement to every other holiday. So like Christmas has Christmas Eve, Christmas Day. New Year's is New Year's Eve, New Year's Day. If she has them on Christmas, even Christmas Day, then I want to be able to have them New Year's Eve and New Year's Day. And then vice versa, because every year is different.
Yeah. All right, if you're in agreement of it, get down here, get a stipulation in order,
Okay.
prepare it as to what you agreed to, submit it to the court, and I'll sign it and so will the judge.
Okay, and then the biggest thing is
Ma'am, do
the
you
100
agree on that?
mile.
Ma'am, do you agree on that parenting time thing for the holidays?
No,
Why? What do you think should happen?
I would like it to stay as it is in the divorce papers because at the beginning I work every other weekend. So every holiday is different for me. So I get worked either Thanksgiving or Christmas, and in the agreement in the divorce papers is the parenting time was granted upon a mother's schedule because my schedule changes for work.
Where does it say this?
And right, I got the paper.
Parenting time shall be reasonable and mutually agreed by the parties. Then you submitted something here that talks about a parenting plan, but it's never been made any court order. I mean, there's no court order.
I have the picture. Hold on.
What?
I sent John a picture of it.
I have the same thing you have, this, Your Honor. The judgment of divorce.
The judgment of divorce doesn't say anything about it being at your, based on your schedule, man. Parenting time,
Well, it says right here on the complaint of divorce with children,
yeah,
it is in the best interest of the children to award specific parenting time according to parenting time scheduled to the mother.
it is. In the complaint for divorce, that's nothing. That's your complaint for divorce. Doesn't mean anything. That's what you're requesting. Physical custody, legal custody. I mean, the request from the father is that he get physical custody and that the mom have specific parenting time.
Right. But now I want that changed because now he's using my medical against me when he now supposedly has medical conditions of seizures that are not properly, they're working on his medication, and he said, and so I don't understand where he's trying to think he's going to get full legal custody of the children.
I mean, you're not, I don't understand what you're
I don't
asking for at
get
times, and
the,
that there's nothing in these orders that you're talking about. And you're dealing with things saying the court ordered stuff and they didn't. End of story.
well, when the cops were involved on Sunday, the officer said that if you don't have a breakdown of the parenting, we
Yeah,
cannot legally make her hand those kids over.
that's right. And there isn't anything specific. It just says
Exactly.
reasonable. But also,
But I just
but it's
wanted
as much for him as it is
clarification.
for you.
Right. I just wanted clarification if that was part of the parenting thing. I didn't know it was separate.
There is nothing in the court orders that it says parenting time shall be
Right.
reasonable and mutually agreed by
Thank
the
you.
parties. That's what it says.
And
Right?
that's what I tried to explain on Sunday, and he's trying to deny it.
But he has physical custody.
Right. But that has nothing to do with the children. For them to
What does it have to do
legally
with
have me
What does it have to
hand
do
them
with it
over.
if it doesn't have to do with the children?
That's what the officer said. That's why he's doing this, because I wouldn't hand the kids over to him.
All right, well, we're gonna set up a specific parenting time.
Okay.
All right, so that you will.
Okay.
All right, you guys don't live anywhere near each other. Where do
No,
the
that's
kids go
why
to
we
school?
made it every other weekend.
Where do the kids go to school?
They go to school now in Newaygo, at Newaygo Elementary.
Who lives in Newaygo?
I do. We just moved up there. I'm waiting for the approval on the trailer. and then we will be moving into a trailer.
All right? So, what, you each get, she gets every other weekend or something?
Yes, we agreed to every other weekend, and then when we were in front of Judge Hillary, he explained to her, because in our divorce, in the judgment of divorce, it says pursuant to MCL 722.31, neither party shall move more than 100 miles away from where they live at the beginning of the case, which at the beginning of the case, I lived in Grand Rapids, and she was staying with her sister in Wayland.
So-
Now
And
she
then-
lives
In
just
Mount
a little
Pleasant.
shy of 300 miles from, well, she's 281 miles from Grand Rapids.
Yeah, and they said that was fine because I have a full-time established job here.
That's
So they
fine.
closed that out.
I don't know what we're even fighting over here right now. You get every
Because
other
he's not
weekend, man.
happy. He's
Ma'am, you
not
get-
happy that he's not getting his way of when I told
I
them.
am telling you right now that you get every other weekend
Mhm.
parenting time. You guys can meet halfway. Where's the halfway point?
If you calculate it right, it's like the Okemos
Okemos?
exit area. So just like in Lansing area.
I know where it is, like exit 110 or something.
Yeah.
It's, sir, do you have a problem with doing halfway?
Well, halfway now that I live in Newega would not be Okemos anymore.
All right, somewhere near there. Let's not.
Yeah. I mean, we
But-
did it on Sunday at the Portland exit, which is fine. I mean, it's an
All right.
hour and 5 minutes from me.
That's fine. How does that work for you, sir?
I mean, that's fine.
All right, exchanges are to take place at the Portland exit. I don't know what, I mean, the
There's
kids
like-
go to school and you gotta get them there. You can't get them there much before 5, 6 o'clock, I don't think. Is that correct?
I picked the kids up at 3:20. So we probably, if I leave right as soon as I pick them up, yeah, we wouldn't be there till almost 6 o'clock.
Exchanges will be at 6 o'clock at the Portland exit, and on Sundays, it will be at 5 o'clock. Cause the kids
Okay.
gotta get home.
Right? I agree.
Does that work for you, sir?
Yes, sir.
It's every other weekend. Is this weekend her weekend or not?
No, this weekend would be my weekend.
All right, starting the following weekend, every other weekend, if you wanna work on parenting time for holidays, we'll work on it. Because I can tell you, it's gonna come down to every other holiday is what it's gonna ultimately end up at.
That's
Right.
what I would agree to, is every
Yeah.
other holiday, and I don't mind her having them. Like if it's Christmas for her, she can have them Christmas Eve and Christmas Day. I would just like to have them the next holiday, which would be New Year's Eve and New Year's Day. I actually had to plan to take them this past New Year's to the ski lodge up in Boyne Mountain, but because of all the problems that we had, I was not able to do so.
All right, well, either you guys are gonna agree on it and come up with an agreement, you're gonna talk about it, or I'm gonna have a hearing on it, and I can tell you what I'm probably gonna do.
Every other holiday.
I'm probably gonna do every other holiday, even though
That's
you
fine.
guys should work on when you have to return and stuff like that, since it's a long trip there, maybe. I mean, like,
Could we just start with working on that and then if
every
we
other
can't agree
holiday,
on it?
and you'll meet at 10 o'clock in the morning and 6 o'clock at night. That's the best
Okay.
you can do.
I'm in agreement with that, with the holiday thing.
Every other holiday, meet in Portland at 10 in the morning. And return at 6 o'clock at night. That's a lot of driving for very little time.
Right.
And I don't even mind if like she has them say,
But it
for instance,
also depends on if I work that holiday too. Cause I alternate holidays
I don't know
at
what
work.
you're gonna- That's up to you to figure out with you and your work and him. You can always exchange. You don't need
I
me, but that's what's the order's gonna be.
if she
Okay.
has to work, the holiday, I can always drive to her house and pick them up. That is not a big deal.
You guys can figure that out, okay? The order is going to say
every other holiday.
10 AM to 6 PM on alternate holidays for her.
Okay,
All right, good luck.
thank you.
We're adjourned. Monro versus Swain. This is a motion by the father to reopen a case that was closed. All right, and it seems to be appropriate. Ma'am, what are your, why wouldn't I reopen it? You guys reached an agreement in September of 2023 for week on, week off, plus certain holidays and tax exemption, all right? So, why wouldn't I keep that going? Ma'am?
Well, I wasn't planning on coming back to stay permanently. So when I agreed back then, it was beneficial at the time. So I just removed, but before I moved, I went to legal aid and asked them because I was going to go to court about it. And they told me that the case was closed.
Yeah,
So
well,
she told me
that was
take him to,
basically a court's mistake. And so I'm gonna reopen the case. All right? Because I believe it was a mistake of the court to close it since you guys did have an agreement that should have been enforceable. And I don't know why they just closed it. I guess maybe something didn't say custody or something like that, but I can't, going through the file and even talking to other referees, I can't figure out why it just got closed. I mean, he's had week on, week off since the, September of 2023. And now, because the court closed it, I'm not inclined to agree with. At this point, you're just saying I can go wherever I want and take the child, and he doesn't see the child anymore.
that's not the thing. I still was trying to figure out agreement from here to there because I moved and I don't plan on moving back. So I was just trying to figure out.
Maybe we'll have to have a custody hearing, and maybe the child will come back even if you don't. I don't know.
Oh,
Yes, sir.
wow.
mean,
Yes, sir.
This is a clerical error by the court. We make mistakes every now and then, and we close a case that I don't know why we closed it. It should have remained open and remained enforceable. In all honesty, I can't see any reason why. There's no reason to close this case, and there's no reason to change the week on, week off without having a hearing, and maybe you should be allowed to go there. I don't know. I don't even know where you went.
I'm in
Yes.
Arizona. I went down there and communicated with them. I was trying to do things the right way. I was trying to get a motion going. And before I even left, I went down there in July.
And I understand what you're saying, and yes, the case was closed, and if you went to me as an attorney or to somebody, I'd say, case is closed, all right? Now, I
Yes,
don't
they
think
told me-
anybody, you didn't even know it was closed,
Yeah,
because you didn't know, sir,
See-
both of you didn't know, just bear with me, you don't need to help me right now. She didn't know it was closed, you didn't know it was closed. Legal advice, I would think, would have been, wait a minute, the case is closed, you can go wherever you want. All right, that would have been my legal advice to her until I found out that I think this is a mistake, that the court closed this case mistakenly, with a court order in place for what was to happen with the child. And so, when did you move to Arizona?
I moved December 6th. I left December 6th. I still exercised that up until I left. So I didn't just stop. He had him the first week of December. He came back with me on the 1st. I left my week.
Can I say something, sir?
No, he's not getting any time.
No, at all.
You can say something, but I've already said everything for you. I don't know what you want to add.
Yeah, she didn't inform me of him leaving or them leaving or nothing. She wrote me actually literally the day before my week was supposed to start back and told me, "Oh, I'm out of town. We won't be meeting you."
Yeah. So how does that help how does that help anything?
It's just like, how is you saying that you going about stuff the right way and you just up and leaving
Because
and
Because I went down there in
she
July.
received information that the case was closed it was closed. There was nothing
Sir.
open at the time, all right? And I'm conceding that it's probably the court that made a mistake, but she knew it
Yes, sir.
was closed, all right? So she didn't have to abide by week on, week off, is what she was saying. It's closed.
Yes, sir.
I went and checked and everything. Now, the court made a mistake and it's fallen on you. I understand, sir. I understand that that's fallen on you, and we're gonna have to have some kind of hearing to determine what is appropriate. So you can have some time with your child. How old is the child?
3,
Three.
he'll be 4 on the 27th. And he's now in preschool. He wasn't in school there. I was waiting on
But
Mr.
you just,
Monro to help put him in school. It doesn't matter because
I'm
at the
gonna
end of the
issue an
day,
order, I'm gonna issue an order reopening this case and setting this matter for an evidentiary hearing regarding custody parenting time. All right, I don't know what I'm gonna do. I have no idea, but I'm just telling you, I'm gonna reopen the case.
and then it's,
And I'm going to, I mean, I think the order of 9/12 should remain in effect, but the practicality is we're gonna have to have an evidentiary hearing regarding custody and parenting time. Cause I gotta figure out, since the court made the mistake, I think, I gotta figure out what's gonna happen from here on.
can I say something?
Yeah,
Well, when I went down there and asked them how to go about it, and they looked into the case and told me it was dismissed. I asked them, how did it get dismissed? I was told he stopped complying with FOC because FOC reached out to the both of us
oh,
with
no,
an updated
that's wrong.
order.
that's wrong.
You don't have to,
Very wrong.
sir, stop. I'm giving you what you asked to reopen the case, all right? And now I'm gonna have to figure out what to do with it now that it is reopened. It's not because you didn't work with the friend of the court itself sent out a notice saying, we're gonna dismiss for lack of progress because you guys haven't done anything in the file. Then they sent it out and just said, we're closing the file because you didn't do anything on it. That was done the case was dismissed 5/14/24. But you guys kept doing the same thing all along. And that you have done what I consider disturb and establish custodial environment, because both of you had an established custodial environment with this child. Both of you were parenting this child regularly, okay? And I find it kind of disheartening that you, regardless of the reason you moved to Arizona, he's losing a lot of time with a child that he has a very close relationship with. And I'm gonna have to figure it out. You'll get notice, ma'am, you're probably gonna have to give us your address, because I don't know if we know it now, but I don't, oh, yes, I do. Don't say what it is, because we're on YouTube, but are you in Mesa?
No, that's not the correct address, and I sent the updated address to the courthouse, so it should be coming.
Can she just?
Do you have my clerk's email?
No, can I get it, please? 1 second. Get the pen.
So you can email it, because I want to make sure you get notice of this. I don't know.
Yeah, he sent me a screenshot of it, and then I had to call up to court because the screenshot he sent me said in person. And I'm like, there's no way I can come in person. So I had to call.
You're here this way, and we're gonna deal with a lot of different things from here and there. Because I'm probably not gonna make you drive back to have the hearing, but you're
What's
gonna
the
have to follow
email?
through on the hearing. The email is Tracy, TRACY dot Dewey, DEWEY.
DWEY.
DEW
Oh, DEWYEY.
at Kent County
Kent County,
MI
MI.
.gov, GOV.
.gov. Okay.
Please contact my clerk today with your address so that we can make sure you get everything. Because we're gonna send it to the address, and if you don't get it, that's your responsibility. All right?
Okay.
All right?
Yes, Your Honor.
So good luck, everybody. I'm gonna issue an order that reopens the case and set this for an evidentiary hearing regarding custody and parenting time. Good luck. Thank you. We're adjourned. Rubio-Perez versus Lackey. We have present the plaintiff. The defendant has been notified of this for 8:30. It's now 9:15. He hasn't logged in, not in the courtroom. We have Ms. Michelle Smith-Lowe from the Kent County Prosecutor's Office. This was a request to enter a judgment of paternity. I did see that there's a paternity, a DNA test that shows him 99 point, a whole bunch of nines after that percentage, that he is the father. So I think it's appropriate that we enter that judgment, as he clearly is the father of this child. You calculated the support here. Apparently, Ms. Smith-Lowe, if you wish to say anything about child support?
Yes, Your Honor, I can place that on the record. After a pre-hearing conference that was held on December 4th, with actually with only Mr. Wilson, I wasn't able to reach Miss Rubio-Perez that day. Calculation was for one child was based upon her actual income of $15 an hour at 40 hours a week with 209 overnights. And that's information that according to him, now that they know that he's the father, he has the child 3 nights per week. But Miss Rubio-Perez has 5 other children, and Mr. Wilson's potential income of $15 an hour with 156 overnights and plus 5 children. The uninsured medical split is 55% plaintiff, 45% defendant. We're asking for entry of the judgment as proposed.
And what's?
Am I able to say something real quick?
Yeah, I'm gonna give you a chance. There's a minute.
Oh, okay.
What is the total amount then?
The base,
$31?
yes, the base support would be $14, ordinary medical 17, and the total is $31.
You know, my only question was, I mean, apparently he's consistently been an auto tech with a lot of experience. He's 31 years old. Is that an average amount or something for an auto tech, if you know?
It probably isn't the amount for an auto tech, Your Honor.
While you
but-
look that up for just a minute, I'll ask Ms. Rubio-Perez what she,
Okay.
Ms. Perez, what do you have to
Yep.
say?
That I seen, cause he texted me and told me that he told the lady that called him that he has her 3 nights, and he pretty much told me like to keep up with that lie, but I'm like, no, cause he doesn't help me at all. She doesn't even know who he is. He never met her. He doesn't even have a picture with her. I never even heard from him again.
So does he have any overnights with this child?
Never. He never got her, ever.
How old is the child?
She's gonna be 2 in May 9th.
Okay, and you say he has never had an overnight with her?
Never. I met up with him in a gas station before we got the paternity test, and he seen her for like 3 seconds, but he kind of was like not feeling her. Like he really didn't care to give her much attention. And then after that, he got the blood test and he was like, oh yeah, I got it. I see she is mine. And after that, it was back to the regular, him doing him.
Is it, Ms. Smith-Lowe, is that the one who told you he gets 3 overnights a week?
Yes, Your Honor.
Well, based on her statement, and ma'am, please raise your right hand. Do you solemnly swear affirm testimony given in this case to be the truth, whole truth, and nothing but the truth?
Yes.
Yes, you just told me that we calculated child support for Mr. Lackey at him having 3 nights per week, and you said that he has never had an overnight. Is that true?
Never had an overnight.
Has yet to have an overnight with this child.
He's never stayed a night. He hasn't even been with her more than an hour.
All right. Based on that testimony, I guess we'll recalculate the child support. Even if it's at $15 for him, imputed at $15, that's probably even low because I think I have to believe a auto tech would be higher, but at 0 overnights, you can recalculate that. And
I will, Your Honor. I guess I calculated it trying to be equitable, since Miss Rubio, was actually making $15 an hour, but I can, obviously, an experienced auto tech would make more if the court desires for me to do that.
Well, why don't you take a look at that? If an experienced auto tech makes more than $20 an hour, which I think they do, but if they do, I'd like you to calculate it at $20 an hour, his support, all right? If
Okay.
they don't make at least $20 an hour, you can do 15. I'm giving you that, all right?
Okay.
And 40 hours with 0 overnights, and that will be the order that we'll enter. Are you all right with that, Miss Rubio?
Yes, that's fine.
All right. Then I'll enter that order when I get it, all right?
Sounds good.
Thank you very much. Take care.
Yep, you too. Bye.
We're adjourned.
Thank you, Your
Thanks.
Honor.
Jackson versus Howard. Mr. Howard is present. Miss Jackson, I think, originally logged on, but is logged off. Ms. Rummelt is present. From the Kent County Prosecutor's Office, this is a request from the Prosecutor's Office to enter judgment of paternity as well as a support order. Kyrique, I believe, is the child that was tested to determine paternity for Mr. Howard. It came back 99.9% plus. So clearly he is going to be the father of Kyrique. And then as far as child support, plaintiff is now logging in. Is she connected?
Hello.
Hello, turn on your camera,
Hi.
please. I've just introduced the case primarily about Kyrique, who has been tested and is found to be that Mr. Howard is the father of that child. Ms. Rummelt, is there anything you wish to say about the, well, does either party want to say anything about the judgment of paternity? It's clear that he's the father.
Yeah. Can I say something?
Yeah.
Can I get a paternity test for the other 2 kids too?
No. You already have a support order in them.
Also, there's no way possible I can get a DNA test for the other 2 kids?
Why? I mean, why? You were found to be the father of this one, and you've also been, you have a support order from earlier last year. You didn't contest it at that time.
I didn't get the order. I haven't got anything, any email, anything.
Well, Ms. Rummel, do you care to address anything?
On the DS case that's before us, in front of the court is both 24007106 DS for 2 children and then 24007108 DP for the child who was tested. The DP will be the lead case, so we're entering support for 3 children today. The children subject to the DS case, Mr. Howard certainly can file a motion under the Revocation of Paternity Act if he wants to seek genetic testing on those children. But at this point in time, he's not entitled to a genetic test. Thank you.
You just heard it right there. If you can file a ROPA motion, then it'll be up to me to decide. But it's not before me today. Then you have to have proper notice for like Miss Jackson anyhow. And then the child support order is for 3 kids. And I don't know that I have the amount.
If I may, Your Honor,
I'm on the wrong case number, I think.
Okay. I did have scheduled pre-hearing for December 10th with parties, but neither participated. Child support for the 3 children is based on plaintiff earning an imputed income of $12 an hour, working 35 hours a week, with 365 overnights and no other children. I imputed defendant at $14 an hour, working 35 hours a week, with no overnights and no other children. The calculation resulted in base support of $522 and ordinary medical of $59 for a total order of $611. The uninsured medical split will be 48% to plaintiff and 52% to defendant, and the effective date of the order is September 1st of 2024. Birth costs for all the children are waived.
I was gonna say, I'm not employed right now, so I don't know how y'all calculated that.
Because you gotta get employed. You can't just sit around and not support your kids.
Yeah, I mean, of
You
course.
used to be, you were employed before, your last employment, you're in 15.50 an hour.
I was what now?
Your last employment, I have here that you were making like $15 an hour.
Yeah.
Yeah, well, we're only saying we're only imputing you making $14 an hour. You can go out and work at Wendy's for that, then, those kind of things.
All right.
Yeah, you have to work. You can't not support your kids.
I mean, I support my kids, but why do I have to? All right, I'm gonna talk to my lawyer. I ain't gonna talk to you.
All right, you go talk to your lawyer. I believe imputing him at 14 an hour is kind of a gift for 35 hours. He was employed before at 15.50 an hour. There doesn't seem to be a reason that he can't work, not disabled, has no other children. I've gone through the imputation factors. They appear to be appropriate. Ma'am, do you have anything you wish to say?
Well, we have a schedule because I'm working. I go to work full time right now. So I was wondering if somehow we can work like the schedule out so both of us can make our hours going to work. If that's possible.
That's up to you to work with him.
Okay.
All right, how much you earning at work?
I would like to switch to part-time.
You what?
I want to switch to part-time.
Well, how much do you make an hour?
17.50.
17.50 and you're working full time?
Mm-hmm.
Well, then we're gonna have to recalculate this based on you making 17 an hour times 35 hours a week. It's not gonna make a huge amount. Your income doesn't mean quite as much as his income does because you're the custodial parent, but it will make a difference. And
Okay.
he'll pay less. All right, Ms. Rummelt, if you will make that change, if you will, there are 17 an hour times 35 hours as, that's $5 an hour more than we had her imputed as. And, I'll sign that order based on that.
All right, thank you, Your Honor.
Thank you, everyone. Good luck. Thank you. We're adjourned. Hello? I take it you're pulling over right now?
I am.
Thank you, because I can't do it while you're driving.
Yep.
All right. How did you get Mr. Notice to Mr. Havener?
Mail.
Mail, like when, a couple weeks ago or what?
Yeah.
All right, this is the case of Havener versus Havener, case 21-6027-DO. This is a request by the plaintiff for a ROPA test, a DNA test for Nova, who was born. I assume that since this was a divorce that was entered back in 2022, that what your problem is right now is they're saying you must have been pregnant or something with Nova at the time of the divorce.
Correct.
So by definition, Mr. Havener is the legal father.
Correct.
And you're trying to say he is not, and you're sure he is not, correct? All right.
Yeah.
I will issue an order for a DNA test, all right?
Okay.
I don't know if, I mean, it will be for Mr. Havener and Nova. However, here's what happens sometimes is, do you know who the father is?
Yes.
Okay. You know what? If you give me a DNA test with Nova and the father, okay, and show that he is the father, biological father, I'll deal with it the same way as if Mr. Havener is not.
Okay.
It might be easier for you.
He already did a affidavit of parentage,
Okay, but
he's willing to do a DNA too.
yeah, it doesn't work because you haven't eliminated Mr. Havener yet.
Right.
All right.
Yep.
So send you out a notice that says do a DNA test between you and Kevin, but I don't know if you even have any contact with Kevin.
I do not.
And so I'm just giving you a hint that says if you give me something that shows that the father is the father, whoever his name is.
Nathan.
Yeah, Nathan. Then I'll deal with it. Same, renotice this after you've got all the information.
Okay.
That says he is the father. Renotice this, and we'll probably just eliminate Mr. Havener as the father.
Okay.
All right?
Done. Thank you.
We'll send you the information so you can go get the test. Make sure,
Perfect.
I mean, it's not, it can't be a home test or something.
I know.
I gotta know who it is who's doing it, okay?
Yeah.
Good luck. Thank you.
Thank you.
See you soon.
Bye.
Bottom line is, this is a motion made by the plaintiff, and I'll explain that in a minute, for parenting time. The plaintiff is represented by Mr. Sherlin. The defendant is represented by Miss Osborne. It's a very unusual case. The father, in this case, was seeking parenting time. Suffered an aneurysm and a couple of strokes, I believe, back in November. From some of the notes I read, there were times that I don't think he was expected to survive. He did survive through an operation. He is in Mary Free Bed for rehabilitation. I have no idea how long. I don't know what his condition is. And basically, there's a 9-year-old child who is admitted by everybody that has a great relationship with his father, but right now his father's in the hospital. Mr. Sherlin, I've read your request and I've read Miss Osborne's response. Basically, you're asking for some type of time. Let me make it real clear right now. I'm not going to change anything regarding custody. I think this is a temporary thing. I hope it is. We can deal with that at a later time, if it's necessary. Dad's recovering at Mary Free Bed, and you're trying to get some time where the child goes to see the father.
That's correct, Your
Mr.
Honor.
Sherlin?
Yes, and so the update, and I'm really pleased to provide the court with an update that my client's parents just showed me a video of my client walking, albeit with assistance, but walking under his own power. Also, he's a keyboard player and he was actually playing the keyboard. You know, he's texting, he's, you know, all the right neurons are firing and he's, you know, coming back to be his old self. We don't know this for sure, but there's been discussion that he may be able to go home in 3 to 4 weeks. Again, nobody's given a discharge date, but there's been that discussion. So, you know, I think it's fantastic, you know, that the progression has been so strong. Your Honor, I appreciate the fact that you've read this. I'm just looking for something on a temporary basis. And here's the context of it. Before December 24th, there were 3 visits. And on the 3rd visit, the defendant suddenly shifted gears and said the only way that the minor child could have contact is if my client's parents were supervised by her husband. And
well, you don't even have to go through that because that's not going to happen. That's not.
All right. Well, and you know, Your Honor, there's
this is a bad situation that I should not even be involved with anyhow, because quite frankly, the family should have figured this out, especially with the temporary nature of it, and especially because the mother even admits that the child has a great relationship with the father. However, the reality is he just can't have the week on, week off that he did before.
at least not for
I have no idea when, if, okay? I mean, I don't know, and nor do you, okay? I mean, if he comes back and is 100%, I'm sure that the court will look at it and give him back to it, okay? I don't know, and I'm glad he's making progress, but I think.
The problem here, though, is the defendant she actually goes into the ICU and tries to hand him papers while he's in the ICU.
That's all done. It's in the past, okay? I'm not gonna paint her as a bad person at this point. I don't think she knew what to do. I'm not happy with that. She scheduled a custody, I think, motion in front of me when he was unconscious, and I said, I'm not gonna do it. I told my clerk, we're not gonna do this. It just isn't gonna happen, all right? I gotta know what's going on.
All we're asking for, Your Honor, is, you know, 2 evenings a week that my client's parents can facilitate until, you know, we can revisit this when my client returns home, but just 2 evenings a week and then alternating weekends. And so here's the value of allowing my clients to do a Friday to Sunday. and one of these recent visits that was controlled, if you will, by the defendant's husband, they showed up right at my client's dinner time at the hospital. If we can let my client's parents facilitate this, then they can work the schedule that provides for optimum contact between father and son.
I'm not giving grandparent visiting time right now.
It's not grandparent visiting time, it's facilitation of my client's parenting
You can
time.
call it what you want, I'll call it what I want, okay?
Okay.
I'm not gonna do that. I'm gonna require that I think the guardians should be allowed to take the child there for a couple of times a week. He needs to see the child. But I'm gonna also hear from Miss Osborne first. I've already kind of tipped my hand what I'm gonna do. I'm not gonna
Well, what
change.
about, Your Honor, though, when he returns to his house, which could be in 4 weeks, and I don't want to have to deal with the delay?
Well, you can renotice this because I don't know. I don't know what condition he returns to the house in. Is he fine? Can he do stuff? Is he going to be almost, I don't want to say bedridden, but how
Okay.
much will he do? Will he not be able to do?
All right, so that way, that works, because if my clients hear that, hey, he's gonna be discharged in a week or in 2 weeks, and I can put it back on the calendar, right?
You can renotice this motion and not have to file a new one.
Okay, that'll work. Perfect. I appreciate that very
Right,
much.
but I'm gonna urge Ms. Osborne and you to deal with this, okay, in a rational manner. Ms. Osborne, I'll hear from you now, please. Well, I would hear from you, but I can't hear you.
Oh, can you hear us now?
Yes, I can.
All right, perfect. We are more than willing to help facilitate visitations between the minor child and the dad. And we are okay if the grandparents want to be the supervisors for those visits. We're okay with a couple of nights per week. The only issue that my client had was the overnight weekends with the grandparents that
I
she
said
didn't
I'm
think
not
was
gonna
in the
do
best
that.
interest. Right. So if we're in agreement with just, saying a couple of visits a week, we're okay if the grandparents want to go and pick the minor child up from school and take them to visit dad. We're okay with all of that. The only thing we will say for the grandparents to know is that he is going to be starting soccer. I think next week. Was it next week?
It starts in February.
Oh, it starts in February, so a couple of weeks. Hopefully dad's home by then. But for the month of January, whatever days work for them, we can work out what days those are. But
Well, you see,
you know-
I don't want to pick the days, but I have to to make it enforceable unless I'm assured that he's going to get those days. I mean, I would think, here's my initial thought. He gets every Tuesday and Thursday evening, okay? By the time they pick him up and get him there and a few hours, obviously the child has to be supervised while there. You can't just leave a
Correct.
9-year-old child at Mary Free Bed, okay?
Correct.
And there's no reason that he can't be home by 7 o'clock or something like this. This is a 9-year-old. You pick him up after school, and I mean, I would expect the grandparents probably, I don't know whether they get something to eat at the hospital or whether they get him something to eat and take him to see dad and do that every Tuesday and Thursday. And I would also suggest a longer period of time on Saturday or Sunday. I don't really care which, if one's better for it than the other. 4 or 5 hours to do that, that'd be fine. I'm not gonna give weekend parenting time right now, but unless I have to, and if I have to, I'll order it. This seems like something that I shouldn't have to do as a referee, because I'm not there. Everybody else knows what's going on at Mary Free Bed and how good he's doing and how that kind of stuff, okay? But I will tell you that I'm gonna order, if you want to put it into an order, 3 hours Thursday and Tuesdays and 5 hours on Saturday or Sunday, and that's the minimum. But somehow you got to work along with this. This is for the child, and I mean, I'm operating in the best interest of the child is what I have to, but there's a certain amount of it that is in dad's best interest, which also is in the child's best interest. Okay. It's in the best interest of the child that his dad gets better.
Mhm.
Okay. And you guys got to cooperate on this some. And if he gets out, you need to have some serious conversations about, I'd imagine he will go live with his parents. I don't think he's gonna walk right out into his own home. And you're gonna have to deal with it there. He certainly is going to get an increase in the amount of time he's gonna see the child. But he has to be able to, I don't know how to say, parent also, okay?
Right.
And you know what I'm talking about, Mr. Sherlin. Geez, Pete, you've done this stuff long enough too. You know what I'm talking about.
I know what you're talking about, Your Honor. I appreciate it. I'm picking up what you're putting down. The one thing though that I need some help with is the defendant has insisted that her husband be in the room at some of the visits.
I just told you no. I just told you this is the order. The grandparents will be there.
Okay.
Nobody else has to be there. One of the grandparents can be there. Both of them can be there. Quite honestly, I don't know if he has say he has an older sister and she wants to be there for it. The child just has to have appropriate supervision. It's not going to be, mom's not going to step in, nor is mom's dad, husband, or anything like that. That's the purpose of this, okay? And if you come back and I find out that somebody else is pushing their way in, I'll push them out and issue costs, quite frankly.
Yeah, and Your Honor,
something that you guys have to get along on and figure this out in the best interest of the child and the father. And that, by that, I also mean, like, if it's Tuesday and Thursday and this young child has something on Thursday and, he might not want to go to see dad Thursday, but want to go Friday instead. Somehow you guys got to figure that out. All right. The order will be Tuesday, Thursday, Saturday. Okay. That's what the order is.
Your Honor, I don't know Ms. Osborne, but I had a conversation with her and I found her to be very very user friendly, and I don't doubt that we can work the schedule.
And that makes one of you as user friendly.
Well, I in fact, I informed her of that, and I'll bet she'll acknowledge I informed her of that. So, and she actually scrambled to get a response in with some fairly short timeframes, and that was much appreciated as well.
And I hope everybody understands what I'm trying to say, because I'm trying to deal with something that should be handled by the parties.
Absolutely. And Mr. Sherlin, if I can, when I first spoke to you, I indicated that we're okay with visits. We're okay with grandma and grandpa being the supervisors. I think when we do the order, when we're preparing that, we should talk about, does grandma and grandpa want to pick him up from school? Who's going to do the transportation to Mary Free Bed? That's all stuff that I think we can work out and make this as user friendly for the clients as possible.
And let me tell you, if there is a problem with it, you guys call my office. I'll have you on Zoom or in here promptly, and we'll force you to figure it out.
No, we'll get it figured out, Your Honor. I really do. Like I said, I had a good conversation with Ms. Osborne, and I think she's probably the more reasonable part of this attorney combo. I
agree.
I'll work on that.
Sherlin for many, many years.
Yeah. We'll work on it. The good news is, Your Honor, this appears to be absolutely a temporary circumstance, and
I hope so.
Yeah.
I hope so, not just for your client, but for his child also. And I hope the mother realizes that too, because she even said in there that the child loves the dad. I mean, there's no question. We just got to get through this temporary thing. So good luck, everybody. Mr. Sherlin, you can draft the order, but with the help of.
Oh, I will. I'll frame something up and send it over to Ms. Osborne and get her input on it, and we'll work it out.
The other thing, I'm not going to say it specifically, but I'm going to say it, but I'm not going to order it. All right. If there's a FaceTime that he can have on a Sunday or a Monday or something like that for half an hour, I have to believe the child also would kind of like to make sure his dad's getting better.
Yeah.
So I'm encouraging you to do something like that. I'm not ordering it right now because it's going to be hard to implement, but allow some FaceTime or I don't know if FaceTime's still the thing anymore, but something like that. Okay.
I think the parties have attempted some of that.
Even a telephone call for 10 minutes or something like that.
Right.
Okay? All of that would be great. I don't know what your client's condition is for that, but I'm just suggesting that, because that's stuff that I will look at to provide later on. All right, good luck,
All right.
everybody. I wish the best, and ma'am, I'm not against you, okay? And in any way, I'm just really hopeful that Mr. Woessner gets through this. It's kind of a miracle that he did. From what I was reading in some of the reports, it sounded like it was the end, quite frankly. And he's come through remarkably, and I wish everybody the best. Take care, and I'll get some order soon. Again, if you need my assistance for a little thing, both of you contact my office. Tracy will get you in here that day.
Thank you so much.
Thank you. Good luck.
Thank you.
Thanks. Bye now.
Good weekend. Thank you.
Same.
Case of Mendenhall versus Sims. We have both parties present, but Ms. Mendenhall is on mute. And now she logged off. As I say, we have Miss Michelle Smith-Lowe from the prosecutor's office. We have Mr. Sims, defendant. Waiting for Miss Mendenhall. Does it show she's connected? There you go. Can you hear me?
Yep, I can hear you.
All right, we now have Miss Mendenhall. This is a request for a judgment of paternity and UCSO made by the prosecutor's office. There was a request. I don't know how to say it correctly. There was no request for DNA for the child, Ava. So the Mr. Sims admits that he is the father of Ava. There was a calculation made on the UCSO, Uniform Child Support Order, basically imputing mother because she had been earning $25 an hour at some point. I'm not sure whether she's working now or whatever. Dad has actual income of $28.43 for 40 hours a week. Is that in essence what you're looking for, Miss Smith-Lowe?
Your Honor, if the court is, I'm not sure if the court received an amended UCSO. This case was originally sent in on this. Let me hold on just a second. Let me look at the note. On December 12th, based upon calculation where I inadvertently left out Mr. Sims's adjustment for one child. And so after speaking to him at the pre-hearing conference, actually we spoke at the pre-hearing conference on December 12th, and then I spoke to him on December 19th. And I called that to my attention, and I resubmitted a calculation that calls for base support of $514, healthcare adjustment of negative $17, ordinary medical of $8, for a total of $505. At the time, he still didn't agree with that amount, but I will let him express his objection.
Yeah, I do not have that one. I still have the 678 amount, but I understand what you're saying. All right. All right, Mr. Mendenhall, what's your objection?
Can you hear me?
Yes. Ms. Mendenhall, do you have any objection to any?
So my only objection is that I'm currently unemployed. So I know that amount had to be put in. So I'm not quite sure if the calculations is correct or not.
You have a long history of working at 40 hours a week and making like $25 an hour.
So that was put in after I was let go from my company. I was originally making $30.29 and currently not employed anymore.
Why not?
So with that, the company did some reconstruction of the department, so therefore my position was terminated. I guess you can put it in that way.
Where are you looking? I mean, your income is not as significant as Mr. Sims in this calculation, but when were you let go?
November 13th.
You're collecting unemployment?
Currently, no.
Why not?
Because I assigned a agreement basically saying that I couldn't collect unemployment. They did issue me I guess a lump sum.
Okay.
Yeah, so they did issue, well, not a lump sum. They gave me a couple more payments after I was let go.
So you've been collecting and through what? Through December or January or what?
Through through January. So I just received my last payment last week.
All right. But that was like 30 some dollars an hour and we're only putting you at 25 an hour. Are you
Yeah.
looking for employment?
What was that? I'm sorry.
Are you looking for employment?
Yes, I am.
Your Honor, the
Okay.
imputation has her at $15. If the court wants me to change that.
No. I thought. No, because she certainly $15 with her abilities can certainly earn $15 an hour. I mean, that's. But where I have it in here, it says you imputed income at $25 an hour times 40 hours. Now, this is the last one. This is not the updated one because it doesn't have him with any children.
That should be 15, Your Honor. That's a type.
All right.
That's a typo.
Well, I find that she, with her education and prior experiences, high school, diploma, 95%. I mean, we know that she doesn't have disability. I believe she has 3 children in her home, but has been able to work at $30 an hour. I think it's generous to put her at 15 an hour as it is right now. And we'll do that, ma'am. Just you gotta work. So, Mr. Sims, what's your objection?
None, I mean, at first it wasn't put that I had any kids. That was my only objection.
Okay, that'll be corrected, and it has been, not in front of me, but it's clearly lowered you from 678 to 505. Okay, so it's clear that Ms. Smithlow has made that correction. So with that having been said, if I get the correct one that basically calls for a total of 505 a month, okay, I'll sign that order.
All right.
All right. All right, ma'am. Good luck. Miss Smithlow, if you'll send that to me, I will sign it, okay?
I will, Your Honor. Thank you.
Thank you. Good luck, everyone. Both parties are present. Ms. Johnson is represented by Ms. Palto. Mr. Jackson is here in pro per. This is a couple of things that we need to deal with. First is entry of a paternity order. Mr. Jackson requested paternity testing. After repeated requirements of mother, she finally cooperated with it. Don't know why it took so long, but she certainly was not cooperative to begin with. Mr. Jackson was found to be the father. Are you objecting to entry of that paternity order, Ms. Palto?
We are not, Your Honor.
All right. Now, then he's also made a motion for at least a temporary order or something of custody. And I've looked in the file, and Ms. Palto, I don't know if you did, but on May 31st of 2024, there's an order that says, per the sworn testimony of the defendant, your client, on May 31st, the plaintiff, Martell Jackson, is not the legal or biological father of the minor child, as there is no affidavit of parentage or DNA and stuff like that. I don't know how she testified that he's not the biological father when in fact he is the biological father. So I'm just warning you, her word isn't particularly good right now. All right, the credibility is lacking. So what are we going to do as far as some type of a order so that because he's going to start seeing this child that's his?
Your Honor, so yeah, the minor child in this case is 3 years old, and I know that Your Honor has a longer history with this case than I do. We were retained a couple days ago.
Yep.
So yeah, our understanding is that the minor child has been residing exclusively with mother since the court ordered in May, and
where was the child residing before that?
prior was residing with Mr. Jackson.
Yeah, all right.
And so since May, there has not been a parenting time schedule in place. That is in part due to the fact that when mother received the child back into her care, she had some concerns about the child's health and also took her in for some routine medical care that then led to a CPS investigation due to a diagnosis that the child had of bacterial vaginosis, which led to an investigation into sexual abuse. She was advised through a safety plan not to allow the minor child to communicate with the father or enter into his care. She complied with CPS until that investigation was closed due to the minor child's inability to complete a forensic interview.
So what you're saying is they didn't substantiate.
They did not substantiate, Your Honor.
And that was back in May when she was also saying that he's not the father.
That was carried through September, Your Honor.
Yeah.
Yes.
Right.
In addition, Your Honor, there has been a history of domestic violence in this case, including some convictions related to Mr. Jackson's conduct against Ms. Johnson, including when she was pregnant with a minor child. So I think we just are asking, Your Honor, understanding that there is an established custodial environment with mother, acknowledging that there's a history in this case, whether or not, you know, that's led to now the child has been with mother for 8 months, hasn't seen father during that time. And so we would just ask that the court would consider that when granting parenting time, for that time perhaps be supervised, knowing that there's been investigations by CPS and a history of domestic violence in the case.
I'm sorry, but first of all, CPS investigated and didn't find anything, okay? So I'm not gonna use that against him. Second, he had the child and then she did everything she could not to have him tested. All right, she even testified that he's not the biological. I know she was there when she became pregnant, all right? And for her to come in and say that he's not the biological father is very bothersome. Then, like I say, then he comes in and just says, look, I want to be tested. I want to be tested. And he had to file another motion, even though she was ordered to be tested. And she didn't do it. All right. I find her conduct to be rather bothersome
Your Honor,
and
yes.
basically contemptuous at times.
We are now entered in this case, Your Honor, and I've spoken with my client. She understands the importance of complying with court orders in a timely manner going forward. She will
I
comply.
don't think she
with whatever
needed
the
an
court
attorney
orders.
to know that she shouldn't lie.
Your Honor, my understanding is that there was a lack of certainty about whether or not Mr. Jackson was the father, that there had been enough.
Certainty is one thing, but to swear that he is not the biological father is something totally different.
Yes, Your Honor.
All right. So, I mean, I'm not just gonna give the child to him right now. I'll tell you that. He hasn't seen the child, but I'm gonna give him some time starting right now that he's gonna get the child so that he can start building that relationship with that child. And we might take a look at it farther down the road, but at least for now, the child knows him. The child until May was with him. It's clearly acknowledged that. And like I say, she has done everything she can to inhibit his ability to see this child. She should have taken the DNA test many months ago, and we wouldn't have had from May till now.
In May, he had it dismissed, sir.
Asia, just hold on. Yeah.
So,
Yes, Your Honor. I think with some also understanding that had the testing been done in May, CPS still would have been investigating and she would have been advised to comply with the safety plan for several months.
doesn't matter whether she's advised or not. I make the decision on that. Okay.
Yes, Your Honor.
CPS can say, you know, no, I don't think you should do that. And I'd be saying, well, wait a minute, we can do a lot of stuff to make sure it's safe, especially while you're just investigating. They can investigate you for armed robbery, Ms. Pelto, even though you were not even in the vicinity or anything to do with it. And you wouldn't want that to be, you know, used against you, especially when they ultimately didn't find anything against Mr. Jackson. You can say whatever the reasons are, but I can't sit here and say, oh no, I guess he must have sexually abused the child, even though there's no evidence of it. All right, because that's what the mom is kind of trying to do, is make me make that finding. And I don't have any evidence of it. Anybody, I get this stuff all the time where people come in and claim he's a bad guy. The CPS is investigating. They didn't find anything.
Yes, Your Honor. I think given these allegations, given the history in this case, we would also be requesting a referral to FOC just to get some clarity about some of the facts in this case.
I don't have a problem. Do you have a problem with Mr. Jackson with referring it to the friend of the court? But I'm gonna give him parenting time in the meantime.
No, I do not. I just want to see my baby.
All right. We got to find a neutral spot to meet, because is there a PPO against you from Miss Johnson?
Ms. Johnson has a PPO, yes, Your Honor.
All right.
She's been trying to do everything in her power for me not to see her.
I understand that. I've gone through that, Mr. Jackson, and I understand, but I can't.
I have
but there-
witnesses from when I had got the PPO.
Listen, there is a PPO and I gotta protect both parties from that. That's as much protection as you, Mr. Jackson, not to be alone with her, so she claims that you did something.
Yes, sir.
All right? Where is an exchange place that we can do for this child? Is it a, you know, Mr. Jackson, can your sister pick up the child? Or I'm just looking for something.
Well, I would have my mother, but she have a case against my mother, so I can't have my mother. So it's like we can meet anywhere possible. Court,
Grand
police.
Rapids Police Station?
Yeah, I don't mind.
Is that real far from anybody?
No.
I'm not sure, Your Honor.
We can meet and exchange at the Grand Rapids Police Station. They got cameras there, and if somebody does something, if somebody does something, it's not gonna go good for them in front of me, I can tell you. Okay, Ms. Johnson or Mr. Jackson, anybody does anything other than just exchange the child, that is not gonna go good for the person who I find out is going. All right? All right, we're gonna start out, and for the next 2 weeks, I'm gonna, Mr. Jackson, you can see the child this Saturday from 10 o'clock to 6 o'clock. All right, just bear with me. All right, 10 o'clock till 6 o'clock, exchange at the Grand Rapids Police Department. All these are, okay? All these, and everybody better act like an adult. You can also see her Wednesday. Do you work, either of you?
I work full time.
No, she goes to school on Wednesday.
Yeah, I understand that, but when do you get out of work, sir?
I work 6:30 to 3.
So, you can pick her from 4 till 7 on Wednesday, right?
Yes, sir.
All right, it'll be 4 till 7 on Wednesday, and that will go for this Saturday, this Wednesday, the next Saturday, and the next Wednesday. All right, just so that she's used to you again. All right, you've been out of her life and it's not your fault. All right, but, and then after that, she's gonna see you on Wednesday night and every other weekend. For now, from Friday through till Sunday.
Thank you, I appreciate you.
All right, and Ms. Pelto, I'm gonna ask you to draft this, please.
Yes, Your Honor.
And then we can do a referral to the friend of the court also, for
Thank you, Your Honor.
custody, parenting time, all that kind of stuff. Let them take a look at it. We'll also do it for child support and all that kind of stuff. All
Yes.
right. All right, so that will be it starting tomorrow at 10 o'clock to 6 o'clock. All right, meeting at the Grand Rapids Police Department right down here on Monro, or whatever it's on, right? Wednesday from 4 o'clock to 7 o'clock, and that's for the next 2 weeks. And then after that, he will still maintain the Wednesday 4 till 7, and he will start every other weekend. That will be his weekend then coming up. And then we'll do every other weekend. We'll refer it to the friend of the court. Any questions about anything?
No, Your Honor.
Pardon? Oh, we'll waive the fees to the friend of the court.
Thank you, Your Honor.
So nobody has to pay $150. Do you understand that, Ms. Johnson?
Yes, sir.
Mr. Jackson?
Sure.
You're
Thank
going to be contacted by the friend of the court. You better cooperate with them, otherwise they only get the other party's side of the story. All right? Cooperate with them, be reasonable. They are not the enemy. And if you're, it'll come back bad unless you guys realize they're not the enemy. All right? And if you don't agree with what they recommend, you can object to it and we'll end up having a hearing. All right? Ms. Palto, I appreciate, and I mean, I sounded like I was kind of pounding on you, but I know you just got in this. I'm not, that was in no way meant to say anything bad about you.
Yeah, I understand, Your Honor. Thank you.
All right, good luck, everybody. Any questions? If not, we are adjourned. Thank you.
Thank you.
Hess versus Van Kyken. Both parties are present. Mr. Van Kyken is present with his attorney, Ms. McLean. This is a motion that has been filed by the mother, the plaintiff. I had some questions about proof of service, but apparently that was fine because everybody's here. And so it's a request for a temporary order in this DC case. Ma'am, is there anything you wish to say as far as what you want for a temporary order? Ms.
For me?
Hess? Yeah.
Yes. So I am being refused any time with her at all. The only time that has been okayed by him is if he's present at his work. So
Okay.
I would have to go to his work site to see my kid. I mean, that's not okay.
When was the
that's
last time you saw
fine.
when was the last time you saw your child?
So the only time I was able to see her, I made arrangements with his parents on Christmas Eve. Christmas
And
Eve, he
when-
gave Braylon up to his father, and his father contacted me to make arrangements to come see her.
And you were in a rehab facility, residential treatment facility for how long?
So I was in a sober living in it's like a home for roommated women who could pay rent up until January 1st, and then I signed a lease to my new apartment.
Okay, and who do you live in the new apartment with?
I live with Gerald. He's my boyfriend. We're both on the lease together.
Okay, you understand what was alleged?
I'm sorry, what?
You understand in the response what they said about Gerald?
Sure. I mean, I don't, he's never officially met Gerald. He hasn't given any opportunity to do so. I don't really know all the allegations that are being said or not true.
Well, the
at all.
daughter says she's seen Gerald naked. Isn't that correct, Ms. McLean?
Yes, it is, Your Honor.
What's going on, Ms. Hess?
As far as for me,
Well, yeah, who's protecting your child when she's with you?
yeah, I have, there's absolutely no issues. There's no issues on either part of my record, his record. We have her own room, great atmosphere. There is no issues. The only issue is the allegations of what he's saying is as far as
I understand.
I don't think are strong
Your
enough. to-
7-year-old daughter is saying it. I mean, understand they're not proven, and I gotta act in the best interest of your child.
Correct.
And maybe the best thing right now is that your child can have contact with you, but no contact with him.
So no contact with me at all?
Contact with you, no contact with Gerald is what I'm considering right now, okay? Until I figure this out.
Okay. What is the reason behind that though?
The potential problems that are there, okay? The allegations that your daughter's making. I don't know.
That she stated to Seth?
What?
That she had stated to Seth?
Yeah, I'm not saying it happened. I'm saying in the meantime, until I figure it out, maybe that's the best solution. Are you willing to do that?
Okay, so how do I see my daughter then?
I'll probably give you some time with your daughter, but it'll be up to you to make sure he's not around when she's there.
Okay. I just don't understand how the allegations are.
I'm not saying that it is true. I'm giving somebody a chance to find out if it is. Miss McLean, go ahead. Why don't you state your side?
All right. Well, thank you, Your Honor.
Is CPS investigating it all?
I asked my client about that. He did not make a report to CPS. He instead made it to the counselor at the school. So they may have. I mean, this is all kind of fairly new. She just went to school on Monday. This week is when. Okay, so she's seen the counselor. So it might still be coming through CPS. What my client
You
did.
reported it to the school counselor?
Yeah, he said, listen, I'm gonna have our child talk to the counselor at school, because they do provide, I think it's like through the San Friscan, like, it's a Catholic school, and they allow for counseling. San Friscan Life Process Center provides counselors to all the schools. And so at that point in time, actually, it's interesting because when Seth reached out to Ashley and said, hey, our daughter reported that she saw Mr. Rice naked, Ms. Hess's response was that she broke up, that they're broken up. And then, but here today, that's obviously not true. So when the child returned to school on Monday, then she met with the school social worker and reported apparently what happened. My client wasn't there when it was made, but he was told that there was the report made. So I don't know if CPS is going to do anything, because my client did take appropriate steps and wants to make sure this little girl is protected. I have to say, for 7 years, the parties got along, and my client made sure that she had a relationship with her mom, even though her mom, has been in and out of this treatment center. Right now, what they were doing prior to this, Mr. Rice's exposure to the child, was Monday through Friday, the child is with Mr. Van Kuiken. He takes her to and from school, he takes her to and from karate, and she's there every night. And then the weekends, the prior to this incident, the child would be with plaintiff from Friday, basically from 5 to 9, whenever it worked. They worked together until Sunday night. But on Saturdays, Ms. Hess would give the child back to Mr. Van Kuiken so she could attend her AA meeting. It was just, and they worked together for all this time. And then they were just sharing holidays. So up until the Mr. Rice incident, there wasn't a problem. There's a lot of concerns about this. I mean, she just moved in there with him a couple weeks ago. She saw him naked, and Ms. Hess is trying to tell her to call Mr. Rice's dad. And, again, these are things that, this 7-year-old is a smart little girl. She's.
All right, but let me interrupt you for a minute. All right, if nobody's gonna do any investigation or figure it out, what do you want me to do?
I think
I'm not gonna eliminate her
no
partner for any period of time unless I have something.
Well, this is all we wanted to do until this is figured out. I think that the simple thing is, for right now, we ask for no contact between the minor child and Mr. Rice, and that we send this matter over to the friend of the court. And go from there, because I don't know what the status will be out of what the child witnessed, but my client doesn't have a lot of confidence in Ms. Hess.
Nobody's doing an investigation, so nobody's ever gonna get to the bottom of it.
Nothing.
I can have him make a CPS report today. I think he was trying to take instead of doing anything, he was trying to work with her directly and say, keep him away from our child. And that was a communication he made. She wasn't honest. She just said, well, we're broken up. Well, he knows that wasn't true. So then he said, well, you can see our daughter, but I don't want you having her around Mr. Rice. So I can have him make a CPS report, but that's why nothing is being done. He did have the child talk to the house.
But I'm also to the point where, so he makes a CPS report. CPS starts an investigator or
Excuse
whatever.
me, I did make a CPS report.
What?
I made a CPS report.
When?
So approximately 5 days ago, out of desperation, I called CPS to look into the investigation.
Investigation of what?
In the case of neglect, he brings her to his workplace all day instead of letting me have my time with her.
That isn't neglect. He's watching your child. She's going to school. You're so far off base, ma'am.
He takes her to his job. She sits there. She was there on New Year's, Christmas. His parents gave me her on Christmas Eve.
Authorized it.
He offered to serve his own son.
Yeah, she tricked me or something. I don't know what she's saying.
I don't have any idea what this is.
This is ridiculous.
All right. So what do you propose?
His own father is agreeing with me.
What?
His own father and stepmom sat with me and agreed and gave Braylon to me on Christmas Eve so I could see my daughter.
So
if that makes any understanding, and they were the legal guardians for her last year.
And Mr. Rice wasn't present and wasn't supposed to be present. And it's not like it was a trick. He told his parents to do that.
and make arrangements to do that. So this is not like it was something he arranged. He didn't want their daughter to go without seeing her mother over Christmas. And did not bring the child around Mr. Rice. So the whole problem is exposure to Mr. Rice.
Right, but how is that relevant to not letting me have my daughter at all?
I'm
If
gonna
there's
let you
no
have your daughter
proven-
some, and it's not gonna be around Mr. Rice. I'm telling you right now. You're gonna get your daughter. You're gonna make your choice between Mr. Rice and your daughter. I mean, you choose your daughter or Mr. Rice?
Fine.
What?
I said, okay, I mean, I don't understand how if you're in a relationship with somebody, we signed a year's lease together.
Okay, so you're gonna choose Mr. Rice?
Well, I'm not saying that, but what I'm saying is that I don't think it's against any type of rules or illegal to move forward in a relationship with somebody.
I'm
and
sorry,
still
what
be
did you
able
say?
to see my
It's not
children.
legal?
Yes, to be able to
You know
see
what?
my
All right,
child.
I'm gonna stop this right now. If in fact Mr. Rice exposed himself to your daughter, you don't think it's legal for me to say he can't be around her? I'm
That
saying,
is legal, but that's not what happened.
I don't know what happened. I'm trying to find it out. And in the meantime, I'm trying to protect the child. I'm trying to protect her because if nothing else, she's not real happy with Mr. Rice because she thinks he
He's
exposed her.
manipulating
All right?
her though.
Well, of course. And I know you're not. So we'll take it from there. All right. When do you wish to see your child, ma'am?
As soon as possible. I haven't only seen her one day since December 9th because of his parents giving me on Christmas Eve. That's it.
Why don't we do the schedule that we had been following, that they've been following, which is I think with her work schedule, but Monday through Friday, the child's been with Mr. Van Kyken, and then every weekend, the child goes with plaintiff from Friday to Sunday. But on Saturday, Mr. Van Kyken takes the child back so that Ms. Hess can go to AA. That's what they had been doing for the last, I don't know how many years.
Gives you a lot of time, ma'am.
And
Mr. Rice is prohibited from being around the child during this time. We'll figure it out later.
And then if you could refer it to the Kent County Friend of the Court, that would be ideal because this is an initial custody case. They had 7 years, they never had an issue.
I understand. I understand. Ma'am, I'm giving you the chance to have every weekend from Friday at like 6 o'clock till Sunday at 6 o'clock. I understand that you attend AA or whatever. I'm
No,
glad.
I'm done with that.
Oh, you're
I'm
done
done
with
with
that?
that.
Oh, boy.
That's not.
I did
that's
not know that. That's not
I'm
good.
completely done. I signed a lease to my own home in East Grand Rapids.
But you were just going to AA. You're not living there, so.
Braylon has her own room here, everything. So I
I'm
don't,
just saying, it
no
has
more
nothing to do with
AA.
it. You're not
No
involved
more.
in any aftercare now?
I'm sorry?
You're not involved in any aftercare now?
No, nothing.
That's a concern, Your Honor, for.
It doesn't matter. She was only doing it on Saturday as it is. I'm not gonna stop her at this point. If she drinks at all or has
I
any
don't.
substances at all, and you will not have any substances 12 hours before or during any time that you have the child.
That's not an issue. I'm totally.
We'll find that out.
on my own.
Marijuana, alcohol, or any drugs.
That's right.
No,
I said any
absolutely not.
I mean, I would like, Your Honor, because my client already suspects it, because Mr. Rice is not, they met, I believe, at this treatment center. And if they're not in treatment, it's a really big concern. And so he already suspects that something's happening.
I'm not gonna do anything further than that. I'm gonna order that she not have any of that. If it appears that that's a problem, I'll deal with it at that time. The friend of the court can deal with it at that time. I'm gonna issue a temporary order that, father has Sunday night through Friday night, and mom has Friday night at, 6 o'clock through Sunday at 6 o'clock. And Mr. Rice at this point, and you'll get a chance to undo this. Mr. Rice is not to be around the child.
And no contact whatsoever with the child.
Contact whatsoever with the child until I get further over to court. I'll fix it at somewhere down the road if in fact he's not found to have anything bad to have done. Believe me, I'll fix it. So.
And again, if it's innocent, Mr. Van Kuyen's not trying to be vindictive or, I mean, he just wants
I
his
got a
daughter
lot of
protected.
motions. Don't, this is just superfluous stuff. I've just made my order.
Thank
That
you.
It is, we'll do, joint legal in the temporary order. All right, so because the parties can work together. I'll refer it to the friend of the court. Ma'am, are you working?
Yes, I work for Oregon.
Okay, so it sounds like, each party can pay for their 1/2 of the, requested amount from the friend of the court to do their investigation on custody. I'm gonna do custody, parenting time, child support. Each party's responsible for $150. If you don't pay it on time, they'll dismiss it and that won't go good for you. It's really pretty simple deal.
Thank
All
you,
right.
Your Honor.
You understand what's going on? You can see your daughter come
Tonight, 6 o'clock.
this afternoon, whatever time it is, 6 o'clock on Friday.
So starting Friday through when?
Sunday.
Sunday.
I would
Friday through
also,
Sunday?
my client has not spoken to the child at all about what she saw. He felt that he didn't want to be accused of leading or anything. So I think neither party should be,
Well, neither party
interrogated,
should discuss it, but I mean, I'm not gonna be there to
police it.
told it, no, so, I mean, obviously, if it gets investigated, these people who investigate obviously know whether or not the child's been. handled.
Coach, yeah, I
And so
understand.
I gotta leave it up to them.
All right, thank you, Your Honor.
That's the order, Miss McLean, you'll draft the order, it'll start today, I believe it's 6 o'clock, you pick up your daughter, ma'am. All right, where are we gonna do the exchanges?
Where do we do the exchanges in the past?
At work.
At work?
Yeah, because I'm always at work.
Okay, so you bring, you bring
You can
it.
come just pick her right up, we can see her right out the window, like send her right out just like we used to.
Okay, in the past, what my client would do is take the child to work and then she would pick him up from, the child up from work.
All right, and then Sunday,
Sunday, how do you do that?
Drop off at work,
And they just meet at my client's work, Your Honor.
work
All right.
or the house.
sounds good. You understand what it is right now, ma'am?
Yep.
All right, no contact with Mr. Rice, we'll figure something out later.
Thank you.
Good luck, thank you, we're adjourned.
Bye.
Ms. Hamilton is on Zoom. This is regarding about a 20-month-old child, I believe. And father is filed for custody in this matter.
Custody?
My understanding, are you guys married?
Yes.
Well, I can't do custody. You're married. Court doesn't get in the middle of a marriage and say who gets custody. I mean, I don't go to my clerk's house and say she gets custody and he doesn't, you're married.
Yeah,
You're married.
I filed for divorce.
If you file for divorce, then I have to deal with it or something, but you are married. I'm not issuing any orders to married couples on who gets custody and doesn't.
Trying to waste time to me.
Why I started this mainly is to just have some order with watching the kids because
You're married. You got to figure it out while you're married. I'm not getting in the middle of a marriage to figure out who gets it. You guys are married. You deal with each other.
Okay, what about front of court or child support?
There was I can order child support if you guys are living separate. And I can order that if she's on like the state assistance, I can make you pay some for it, but I don't order custody and stuff like that. You are married. I don't get in the middle of married people's affairs.
So what about, why was I able to file this?
Well, you can file anything. The clerk isn't gonna say whether or not you can file it. I've seen a lot worse motions than this that are filed that are frivolous. But I don't deal with married couples. So.
As far as
I just don't deal with it. All right. You're married. Deal like you're married. Talk to her. You're married. All right. So I can't do anything as far as the request for custody. It's really a moot point. Okay. So Ma'am, you're married to him. You guys got to figure out your marriage. Good luck. Thank you. We're adjourned. Cody B. Hurley. Both parties are present via Zoom. We're dealing with Xander and Landon, 11-9, I believe they are. This is father's motion for custody. I mean, there's some history to this. There was a FOC order for parenting time. Dad has to get the psychological for that from Dr. K and this kind of stuff to be able to do parenting time. There's at some point, I think there was a no contact order between dad and at least one of the kids or something through 63rd District Court. There was an evidentiary hearing set on 12/7/12/22. I think there was a hearing, but no order was ever presented to the court. I don't know what transpired from that. Father now claims CPS is involved, showing abuse and neglect by mom, says Pine Rest fears for the safety of Xander. I have no proof of any of this. And he said he can't get records. Sir, in order for me to even have a custody hearing, you have to show what's called proper cause or change of circumstance. It's defined in the case of Advarka. What is your proper cause or change of circumstance to allegedly have some type of hearing to determine if custody should change?
At the time that I filed that, I did not have the paperwork from CPS because it takes time. But last week I was able to actually get the CPS report, which shows cause of child abuse. I cannot obtain the Pine Rest report because that can only be obtained by the legal guardian, which is her. So without a court order for me to obtain that, I cannot get that one. But
What,
I did.
did they substantiate child abuse?
In this report, there are.
I don't care if there's allegations. Did they substantiate? Did they find that there was? They at the very end of the report, it'll say there was or wasn't.
There's not enough to take the kids from her, from CPS point, but they did find child abuse from them medically trying to seek help for that the kids do not need. So there is technical child abuse, but it's not enough for CPS to do anything, which is why I filed a motion to be here.
Well, you got to prove by a preponderance of the evidence there's a proper cause or change of circumstance. I don't know if CPS doesn't find enough to do that, how you think that I'm going to find enough. There's got to be something. I got to have some proof of it.
I'm not able to obtain the Pine Rest report, which shows proof, because that can only be obtained by the legal guardian, which is
Now, wait a minute. Are you saying CPS didn't talk to Pine Rest?
CPS did talk to Pine Rest, but they only obtained last year's report from Pine Rest. They did not obtain the current most recent one in November. At the time, they did not obtain that one, which that's the one that obtained or shows.
No, wait, how do you know it shows that if you've never obtained it? And CPS has never obtained it.
I spoke with the social worker there. She's the one that let me know all of this going on.
Ms. Cody? What's your response?
Nothing was substantiated from the CPS cases, and CPS was involved because they were concerned that, like Mr. Hurley said, that we were falsely taking our children to get medical procedures done that were not necessary, and that's not the case, and CPS found that to be not true. They agreed that we were just trying to get services for our children. Our oldest son was recently diagnosed with 8 different mental health disorders, and I have right here with me, I know it doesn't really help, but his psychological evaluation. And I also have the medical disorders that he was diagnosed with. ADHD, persistent depressive disorder, social anxiety disorder, panic disorder, separation anxiety disorder, oppositional defiant disorder, PTSD, and intermittent explosive disorder. And as far as Landon Hurley goes, we haven't been trying to receive other resources for him because we haven't had behavioral concerns with him. But we did with Xander Hurley. And since all of this, he's been on a med change and we haven't had any issues with him.
Okay. When was the med change and stuff like that? I mean, are we talking recently?
Yeah, it came from Pine Rest.
Okay, so he was in Pine Rest and did some there and they made some changes and now he's all right.
Yep.
And you're saying, sir, that her taking the child to Pine Rest is wrong?
I spoke with the Pine Rest social worker, who's Brittany Hines, and she's the one who said that she feared for his safety. She filed a second CPS report, which I'm waiting to obtain, and she called the sheriff's department to do a wellness check on them.
Okay, and did they do a wellness check?
She also claimed that during the time that Malia and her partner came to pick him up from there, or from Pine Rest, that they were explosive in the lobby and cussing at the Pine Rest people.
That's not true, Your Honor.
This came directly from the social worker.
Okay, so I mean, even if they were angry in the lobby, that doesn't warrant a change of custody. I mean, you got to understand that in order to have a hearing, I have to have at least a preponderance of the evidence, more likely than not, that there is a proper cause or a change of circumstance. And as of right now, I have no preponderance of evidence of any type of child abuse or any change of circumstance and stuff like that. I don't know what the Pine Rest people told you. I mean, I'm not saying they didn't, but I mean, that's, you need something of significance in order for me to have a custody hearing. The purpose of this Vidvarka case is that we don't have custody hearings just right and left for every little thing that goes on. There's clearly been some problems in the past with you that are indicated from the divorce file or the DC file in the past. And I think you had no contact with the kids for a while. There's enough to go around here everywhere. But I have to have, I'm not saying there isn't, but you have not proved to a level necessary for me to have a custody hearing. At this point, you just haven't met your burden of proof of preponderance of evidence of a change in circumstance or proper cause to even have an evidentiary hearing. So I have to deny your custody motion. All right, if you come up with something better or something that you know shows a preponderance of the evidence, I'll be glad to have a custody hearing. I have them all the time, but I have to hold you to a standard, and you have not come close to that standard at this point. So good luck, everybody. Thank you. I'm denying the motion. If you want to, you can file it if you have other stuff in the future.
Thank you, Your Honor.
We're adjourned. The Scabby versus Russell. Both parties are present via Zoom. This is the defendant father's motion for parenting time. There is no established parenting time apparently through any court order at this point. There is a uniform child support order that shows dad gets 130 overnights per year, but that's from a separate DS case. Do the parties have any agreement on any type of parenting time or whatever? We need to, otherwise I got to have a hearing to establish parenting time.
I submitted that in my paperwork that we've had the same agreement for the last like 4
but
years.
if she doesn't tell me here, then unless she's signed it and agrees to it, it doesn't matter.
You didn't state who had to speak on that, so I was just saying that I
That's
put
fine.
that
I'm
down on
just
my
saying,
part.
I'm not, I might, maybe I'm getting crabby, but I didn't mean to be crabby towards you. It's just, do you agree with that, ma'am? What do you agree with as far as parenting time? If not, I'll have a hearing and I'll set it.
Right, so I would like to petition for full legal custody of Kalia, and create a visitation arrangement to allow him to see her, because I believe it is in the best interest of Kalia to have a
You
relationship
didn't
with her
ask for
father.
anything regarding custody. You didn't. Here.
No. But then these are the days I propose. I propose Sunday at 4:30 to Tuesday after school, alternate Wednesdays, and every second Saturday of the month from 8 a.m. to 8 p.m.
Sir, obviously you guys don't have an agreement?
No, that's not an agreement at all. That's not even close to what we've been doing for the last 3.5, 4 years.
Is that correct, ma'am?
So this is what I'm proposing. What we've done previously is he gets her Sunday at beginning at 4:30, and then
That's when
she
I'm allowed
returns to me Tuesday. We alternate Wednesdays, and then I keep her from either Tuesday afternoon or Wednesday afternoon until Sunday.
Your Honor, that's the only thing I was ever offered. I asked for weekends and she doesn't give them to me. I've begged for weekends because I have another child and she refuses to give me weekends. I have to move off of her schedule.
But see, asking for them and getting them are two different things.
But she
right?
says that I don't get them or I don't take her, but I ask her for her on the weekends so I can do something with her on the weekends when I don't work. And it's no, you can't get her. You can get her on Sunday at 4:30. And then so that's not like it's all off of what she says when it's beneficial for her. And it's not about me spending time with my daughter.
All right.
I
I'm
can't
gonna have
take her to
have a
church if
hearing.
I wanted to.
I'm gonna have to have a hearing. If you guys can't agree to it, I'm left with nothing else but to have it. All
That's
right?
fine with me, Your Honor.
What?
That's fine with me.
And I think I'm gonna send it to the friend of the court. Because they can look into all this. You guys can actually talk to them. Maybe you can reach an agreement. I should send it to mediation. And he needs to be with his child also. I don't know. I'll send it for the mother has initial custody of this child. Without any prejudice to either party filing for it. He's not filed for custody. But you want a hearing, ma'am, because you want sole legal custody.
Yes.
We'll set it for legal custody and parenting time. We'll send it to the friend of the court. And see what they have to say. Sir, you'll take a look at it. If you don't agree with what they say, or either party doesn't, then you will file an objection. If you don't file an objection, there'll probably be an order entered as far as what the friend of the court says.
Okay.
Both of you work, can both of you afford to pay $150 to the friend of the court?
Yep.
Yeah, we can pay that.
All right, you're gonna get an order that's gonna require you to pay $150 each to the friend of the court. They'll do an evaluation regarding legal custody
Okay.
and parenting time. And see what's appropriate. In the meantime, what is the current status? What are you currently getting, Mr. Russell?
Sunday,
Sundays?
whenever her mom decides to bring her, whether it's 3
Sunday,
o'clock
I'll
to
set a
6.
time. I'll set a time.
And then
Till Tuesday?
it depends on the week. We alternate the Wednesday because I'm not allowed to keep her till Wednesday because it's every week because it's not fair to her mom. So I prefer
All I'm asking you is
Wednesdays
what you're
instead of
currently doing,
Tuesdays.
because I'm gonna make it an order every other week from.
I
this
prefer
week, you'll have-
Wednesdays.
This week you'll have Sunday at 1 o'clock
Okay.
to
And then like Wednesday, if I dropped her off at school, Jakira's mother works at the school and transport her home from after school. So she would go home with her grandma after school Wednesday if we could do that.
yeah. He'll take the child to school on Tuesdays.
Yeah, I take her to school Monday and Tuesday.
Yeah, but I'm saying that will be the exchange place at school.
Well, we do it with our mothers because there's a lot of back history and
That's fine. You'll have Sunday through Tuesday at school. At school drop off. All right, if there is no school, we'll do it at, say, 10 in the morning, 9 in the morning, okay? If there's no school.
Could we actually do
Tuesday-
that later? Because I mean, Jakira works and she wouldn't even be with her mother. So if there's no school, could we possibly
You don't
extend that
work?
out a little later?
You don't work?
No, like she works, so like
You,
she wouldn't
I'm
be with
asking
her.
you if you work,
Yeah, but I don't, my shifts are different.
like what?
It just depends on the day, sir.
Either drop off at school or 10 o'clock. This is just a temporary order.
Oh, okay, okay.
It's in, so you'll have Sunday night, Monday night each week. And then are you saying on the, every other week you generally keep through till Wednesday?
Yes, sir. Every other Wednesday, I drop her off at school Wednesday morning, and then she leaves with her grandma Wednesday after school. And
So,
that's when she returns to her mother.
so every Sunday on 1 week till school on Tuesday morning, on the next week, it's school on Wednesday morning,
Yes, sir.
okay? Sunday, 1 o'clock. To Wednesday at school. Or 10 o'clock if there is no school. This is a temporary order. This is.
Can I ask though why the 10 o'clock is early on during the week, but then Sunday is so much later?
Normally you'd only have her till 8 o'clock.
Why? I was just asking.
Yeah, this is a temporary order. I can't fix everything without a lot more information. All right? And it's a temporary order. It's subject to change once the friend of the court and everything looks at this.
Okay.
And you can always come in and, if you don't like what the friend of the court says, you can come in and have a hearing.
Okay.
All right, I'm only ensuring right now that you get any time because there is none. And if she didn't give you the child this weekend, you got no order. You can't, you can't do anything.
Yeah.
All right. So accept the fact that you're at least for sure getting time each week.
Okay.
Deal with it, and we'll send it to the friend of the court. Make sure you follow what the friend of the court asks as far as payment and stuff, or if you don't, it'll be not, the friend of the court won't look at it and it won't go good when you come in front of me and say, yeah, I didn't make my payment.
Okay.
Good luck,
I
everybody.
provide for my, thank you. Yep.
Is this the week that goes till Tuesday?
So this week he had her up until Wednesday, so this coming week would be my Tuesday, like
Okay.
I'd get her back Tuesday.
Yep. All right, we'll start it. The Tuesday starts this coming Sunday.
Okay, and
So
then
Sunday at 1?
Sunday at 1.
Okay, and then I do just have one question, Your Honor. What happens if a drop off is like, I know this is temporary, but what happens if the drop off order is like missed?
Huh?
Like say due to like a sickness or something of the sort, what happens if I'm like I'm told that he can't pick her up or whatever the case is?
It's never been that, Your Honor. I've never been
You
late a
deal with
minute.
it if somebody doesn't, if somebody violates the order, they'll contact friend of the court, they'll say they violated the order. We'll do it from there. You're either in contempt or not, and it'll come in front of me, and if you say, I didn't get up or whatever, just follow the order.
Okay.
I mean, it sounds like the mothers deal with it anyhow, so whether he's sick or not, I mean, you gotta be able to figure this out.
Yeah.
All right, good luck, thank you.
I
We'll
mean,
see
I
you-
always take care of my child, Your Honor. So
We'll
no
see.
matter what, sick or not, I never miss out. I'm 100% there Sunday through Sunday. So I don't appreciate that comment. It's not just
I
the
don't
mothers.
care. Look, this is all getting into stuff that is not helpful to me.
I know, but you just made it seem like I don't do anything and it's all about the mother, and that's not what it is because I do my part as a
I
father.
don't listen to it. So
Well, you
stop.
just said what you said. She's not just a mom. She doesn't do her job as a mom if you
Stop.
knew her, actually.
Stop it.
You should stop.
All right, I'm telling you that you are not helping your case. Bye. Jeez, Pete, talk about somebody who's shooting himself in the foot. The motion that was filed by Miss Gates, objection to an ex parte that was signed on 12/30/24 by the judge. Let me see if I've got that right here. And I believe the ex parte order. Can you print off an ex parte? Cause I don't think I have the order. I do know that there was one that was signed by the judge. Oh, yes. The ex parte order signed by Judge Hillary on 12/30 says defendant is granted extended parenting time of all his children, not named in motion, until further order of the court. Plaintiff mother shall have suspended supervised parenting time as determined by the parties. Defendant shall bring a motion as soon as possible. Mother brought the motion all right ahead of it, so she doesn't like that ex parte order. It's clear that the ex parte order was put in basically because she was on her way to pick up the kids when she was picked up for drunk driving. Clearly just bad, beyond bad judgment. She was there, and the father also indicates that there was a time a little bit before that where they were at a hotel and this kind of stuff, and she drove home from there with kids and was intoxicated also. Ma'am, what do you have to say?
The evening of Christmas Eve, I made a terrible judgment call.
Yep.
Obviously, I was picked up for an OWI. And I'm
Why
not.
did you even think of picking up your kid when you were drunk?
I don't have any excuse for that. And hindsight is 2020. And if I could go back and change my actions, I would, but I cannot. But one mistake does not make me a bad parent or an unfit.
Kind of concerned about the December 1st date also. Where you brought your kid home when that was supposed to be a fun time at the hotel, and you brought your kid home, and I think it's pretty clear you were also drinking then. I have real concerns about your drinking right now.
So that is not entirely true. It was a birthday party. We had fun. The kids got to swim. There was lots of other adults there. I was not intoxicated when I took my child home that evening. Yes, I had had some drinks earlier in the day to kind of relax, but I was not intoxicated when I took him home so that he could
I don't have you being arrested, so I don't know, but I'm very concerned. I'm just telling you.
I understand.
I'm concerned that drinking has to be a pretty big problem if you go and are going to pick up your child when you're drinking. It's not just it's not like I don't ever drink. All right. I'm really concerned about it. Are you stable living and stuff like this?
Yes. Well, not with the drinking. I have not drank since.
Okay, but what about have you paid January rent?
Yes.
All right. What about some consumer shut-off notices? Are those all taken care of?
Absolutely.
Are you working?
I'm sorry, what was that?
Are you working?
Yes, I work full-time.
Okay. All right, so.
And I have been going to like AA classes. I'm in therapy. I have been proactive about getting ahead of making sure that I can be committed to my sobriety.
Okay, Mr. Gates, what's your thoughts on this?
She's in her order that she filed. There are multiple points that she's trying to make. I wanted to, just kind of like point out some of them. Number 4 on her list is the parent-child relationship. She's concerned about Damien's sense of security and emotional support. It's on page 3 out of 4, sir. So she mentions the, concern of his security and his emotional state. I feel as if that's honestly, that's my concern as well, but I feel that is a reason to why that I have stepped in and took the time to go in and file this motion.
I understand. And, let me just kind of short circuit this. I know she says a lot of things of concern of, taking the child needs her more than he's getting her and this kind of stuff. She better understand that it was her actions that caused it. Okay. This isn't anybody's, this is not yours, Mr. Gates. It's not your child's fault or anything. It's strictly her that has limited the time with him. And it's strictly her actions. So, I don't find any fault with anything that you have done, Mr. Gates. However, I am going to say that Is this more than the first time you've had a DUI or something, ma'am?
No, this is,
All right. I mean, is there other convictions or stuff like this that are notable that I should know about as far as drugs or alcohol or something, Mr. Gates?
No, just that this has not been a first thing. There was issues with when we were going through our divorce. There's been other times where she's been in our vehicles and gotten to small accidents while she was been drinking. There's even been a night where she was taken to jail by the Granville Police Department for domestic assault because she came home drunk.
When was that?
That was back in, I believe, 2022
Okay.
or 2021. So it was
All right.
it was a while ago. Yes.
Yeah, it was a while ago, and I've said very frankly, I'm concerned about her alcohol, her drinking. Okay, and I'm going to take some steps to try and protect it. I don't know that I need to keep the child away from her altogether, but it's going to be a short leash, ma'am, if there's any drinking or something like that. Your child deserves better than that all the time.
I absolutely agree. And I'm willing to do whatever it takes to prove, like, if I have to take a breathalyzer or, you know, whatever you implement, I'm willing to do that. My biggest concern is Damien. And right now he is struggling because of his, like, what has happened. His dad has moved him to a different school, and there's just a lot of change in his life right now, and I know that that is very hard for him, and I know that that is because
You
of
guys have joint legal custody?
I'm sorry, what was that?
You guys have joint legal custody, or who has custody?
We have 50-50 legal custody.
Sir, you move the child to, actually, you moving the child to another school, you gotta ask the court's permission. You know that?
I just was. I'm sorry. My biggest concern was just making sure that he was going to be able to get everything situated and started back up by the time, and he didn't miss any. I've also got him set for dentist appointments. He has a primary care physician with me as well. Biggest concern is that he's not being left home alone. He walks home from school and is home alone until she gets home from work. And then she goes out and does DoorDash and other things to make some money on the side. And he's left home alone. There are other kids in the house. There's another adult in the house. It's a multiple income home. And there's always somebody here to be with him. There's no security issues. He's well taken care of. I've gotten him, he does chores around the house with the other kids. He's on a strict
Here's the
hygiene schedule.
Hold on a minute. Here's the problem. You haven't filed a motion for change of custody.
I have.
When is it set to be heard?
That is set for April 18th.
For when?
April 18th.
April 18?
Yes.
Why is it out so far?
It's just one of the dates that was available on the list that I was shown for a hearing availability.
I'm here every other weekend. Every other week, every other Friday. April 18. I mean, if I get rid of this ex parte order, everything goes back to where it was.
And yes, I understand.
Right? I mean, I don't know why you didn't set it for 2 weeks from now, so I could hear it. And quite honestly, there is probably enough to have an evidentiary hearing regarding custody. I mean, I'm concerned to the alcohol. Is a change of circumstance. Improper cause. That's not to say I'm gonna change custody. What were you guys doing before this happened? Where was he, where was he going? Who was he living with? When, what?
He primarily lives with me. He sees Zachary on the weekends as often as he can when he is not out of town for work.
But you're down in Marshall, right?
Yes, sir.
Jeez, oh Pete. All right. Maybe we should set a custody hearing, but in the meantime, I've got to start giving her back some parenting time. However, if there is any hint of you drinking before, during parenting time, I'm gonna suspend it until we have a hearing.
I absolutely 100% agree.
All right. I don't want to move him again out of school. So we'll have to figure that out. I'm gonna set an evidentiary hearing regarding custody parenting time. I'm going to, because I do believe that Varka is met, and I think it's we've discussed enough here that I think it's appropriate. Are you off on the weekends, man? I mean, I'm gonna give you some time with your child.
Yes, I have every other weekend off, and then like one day during the week. His school has been working with me, and they are willing to have him come back. They're pretty aware of the situation, and I do have like his schoolwork for this week, so he would not fall behind.
When did he start in the Marshall schools?
He started on Tuesday. It was
I'm
the
not
7th.
blaming you, sir. I'm just saying that when there is joint custody, in order to change schools, you got to get an agreement of the parties, or I got to hear it. Okay?
Okay. I apologize.
No,
in regards to his,
again, I'm not blaming you. I'm not pounding on either of you. All right? There's
yeah,
enough.
sir, there is one thing that I do need to mention in what she has wrote down regarding school. She is, and it needs to be mentioned because I need you to make sure that you know this. It claims that he has an IEP class, which is special
I know
education.
what it is.
Okay. Well, within doing all of the enrollment and everything, speaking to his old school and with his records coming to the new school, he is not in any special courses, any speech courses or anything. He has graduated from all of those, so it's not, there's nothing changing that would affect that because he's not in any of those classes anymore. He's already graduated out of them.
He still does have an IEP through Granville schools, though.
Granville, from when I talked to him and the records they sent to Walters Elementary here in Marshall, there are no IEP classes, period. I'll get that information and I'll put it in for the motion for custody, along with other statements from people I have in regards to the night of the 1st at the hotel on the birthday party. I got other things. It's just a little further away, more difficult to enter them into.
Did you understand what I said earlier? I'm gonna set a custody hearing because I think there's enough here to meet Vadvarka, which means there's proper cause or change of circumstance to meet Vadvarka.
Okay.
Right, so I'm going to set you can't change custody on a Friday morning. Okay, so I gotta set an evidentiary hearing. And I don't know where it's gonna go and how it's gonna go, but I've got to get mom back seeing the child. And because you guys live so far apart, it makes it really difficult. But I'm going to allow mother to have every other weekend right now, because you say you get every other weekend off, correct?
Yep.
Friday at whatever time. Where do you guys meet to do the exchanges normally?
Plainwell.
Fremont?
Plainwell.
Plainwell. Boy, Fremont would have been way the heck the other way. Move. That would have been each of you driving in forever. Plainwell. You know where it is then, sir? Obviously it's Plainwell gas station or something like that.
Yep.
All right. What time can we meet there?
We usually do 6 p.m. We do 6 p.m. Friday and then 6 p.m. Sunday.
Okay. We just lost him. Is he coming back?
Yeah.
Hmm?
As soon as he does, I'll bring him.
somehow we lost connection with him. What is you say you have a day off or something, an evening?
It's Thursday during the day, or well, because I work mornings, but Thursday is the day that I have off.
What about if I let you have Thursdays, but you gotta drive up here?
Or down to him.
What?
I would.
Yeah, oh, sorry, wrong direction.
It's
I'll be
okay.
back up in Fremont, okay?
Yeah.
Hello.
The last 2 Thursdays I have driven down there to see him.
All right, Mr. Gates, I'm saying every other Friday, 6 till 6, you guys need to meet at your normal Plainwell, okay?
Okay.
And Thursdays, I'm gonna allow her to come down and see the child from like after school till, oh, he's 9 years old, but 7 o'clock?
That would be the best time because yeah, from 7 to 8, he's got the shower, wind
Yeah,
down.
he's 9-year-old. So you go down and get him from school and have him until 7 o'clock. It's not gonna be worth it to drive up here, take him to a place to eat or someplace fun down there. Can you do that, ma'am?
Yes.
All right, so you'll have every Thursday from after school until 7. If there is no school on that Thursday, you can have them from 2 o'clock to 7 o'clock,
Okay.
okay?
And so I guess my question is just regarding his schooling. He's
I'm not gonna change them right now because I'm concerned and we're gonna deal with that. Trust me, we're gonna deal with it when we have an evidentiary hearing. I'm not happy, but your actions caused it and I'm trying to make it as easy on this young man as I can. I can't, I'd have to give him to you and I gotta see some stuff. You're gonna need to come in and present some stuff to show your sobriety, okay? And it's gonna take some time and I mean, I'm really hoping that this is the wake up call. All right?
It absolutely was.
Because I do think there's an alcohol problem and having an alcohol problem does not mean it's gonna last forever. All right? So I'm wishing you all the luck and even whether or not Mr. Gates feels that way or not, I would hope he wants you to be all better too, because for your child needs 2 good parents, okay? You guys don't have to like each other, but you gotta be respectful and you gotta get along and you gotta parent, okay? And I don't want any parent trying to gain an advantage and stuff like this. I want the parents to parent and be good parents so that the child, when he graduates from high school, both of you are there, both of you are smiling. He doesn't have to feel like, dad hates mom, mom hates dad. I gotta go here, I gotta go there and stuff like that. You understand what I'm saying?
Yes. And honestly,
Grow up and be parents and I actually appreciate you. I was prepared to be a lot more difficult on you, ma'am, but you've accepted your responsibility and you've accepted something and so I'm all right with you. But we'll send out a notice on a custody hearing. You don't have to file that motion, sir. I've heard enough. I'm gonna have it, custody parenting time, and we'll send out notice. You guys are crazy if you don't have an attorney for it. Cause it's a formal hearing. You're not just gonna sit here and talk to me, okay? It's a formal hearing with rules of evidence, which you don't know. I'm sure, all right? Maybe I shouldn't say that. Maybe you do know rules of evidence, but I don't think so. All right, good luck to everybody, and work a little bit together too, okay? I mean, if things work out and Damien can go see you or whatever, work together. But
I just have a question. I'm sorry.
Yeah.
Can I get Damien this weekend as it is my weekend off, or do we have to start at a different time?
This is your weekend off?
Yep.
Yeah. You can get this weekend. If you have to get Damien, I mean, when does he come home from school?
I'll be picking him up about 3:40.
have a little bit of flexibility. Maybe he won't get them to you till about 7, so he can explain stuff and all that kind of stuff and everything, okay?
Right.
There will be, if you understand what happens if there's any hint of you drinking,
Absolutely. 100%.
all right? Be careful, Mr. Gates, all right? You can get him there. If you can get him there at 6, get him there at 6. Otherwise, text her and say, hey, we're no later than 7, but because this is a complete change and he doesn't know he's going there, okay?
Yeah. Appreciate if we could just plan on 7 because I'm gonna have to talk to him and
Yeah.
everything.
So he'll every other time it'll be 6, but this time it'll be 7 o'clock. He'll get them to you, okay?
Okay.
Plain well, because it's a lot closer than Fremont.
Yeah.
Good luck. Thank you. We'll get to the bottom of this. I think we'll fix it eventually, okay?
Okay. Thank
Good
you.
luck. Thank you. We're adjourned. This is a motion that's been filed. Well, both parties are present by Zoom. Ms. Jernigan is here representing the defendant father. This is about one child who is apparently going to turn 18 real soon. I don't know when he graduates from high school. When does he graduate?
Your Honor, I'm sorry. I apologize. He's going to be 17 in February. I miscalculated his age,
right.
but he will graduate next year.
All right, so he's 17.
Correct?
He'll be 17 next month.
Will be, yeah.
He turns what, ma'am?
He'll be 17 next month.
All right, I had him at 18 next month, so. All right, we're dealing with a request from mother regarding child support. There was just a child support order entered in August. There was a deviation from 746 to 0. Reasons for the deviation were it was in the best interest of the family, and also the mother was granted the tax exemptions for the children. There's also another older a child that is no longer part of this. And I note in the order, there's nothing that makes it go beyond 2/6 of next year. Towards graduation, there's nothing put in as post-majority support. So what are we looking at? Why, I mean, what's different, ma'am? You still got the tax exemptions and stuff, so you want to get rid of those and go to?
The tax exemptions were something that they put in that was not brought up to me. It was not part of our discussion. They put it in, which.
So you don't want the tax exemptions?
I don't care either way, to be honest. It wasn't something that I asked for.
Well, why did you sign this agreement?
I did.
Well, then I expect that you knew that was there.
I knew it was there, but I didn't
and that was part of it. And it says in there, that's one of the reasons for deviation. I mean, you're responsible for knowing what you signed, and that was part of the reason for deviation.
Okay, I
It was right there, and you signed it. It said, mother is granted tax exemptions. The value of the property or other support awarded instead of the payment of child support, that was a part of it.
Okay.
So, what are you saying? Dad gets every other weekend, child doesn't want to go to him, is that correct?
Yes. That was my impression, yes.
What do you mean it was your impression? Either the child goes or not?
He doesn't go. I was told by the defendant that he's not welcome until he's willing to live by his stepmother's rules. And Benjamin and his stepmother do not get along at all, which is why why we decided for him to come to me.
Okay. And then you guys just, at the same time, 5 months ago, agreed to a deviation in child support for that time. And now, but you knew he was going to you then.
I did. What I did not know was that there were a lot of expenses that I did not expect right away. started his therapy. I have to get him I had him evaluated for depression, anxiety,
You have insurance?
and yes, I have insurance. At the time, he was still on his stepmother's insurance, and I encountered problems with it. I spoke with the insurance company. They told me that they had been trying to get a hold of her and she was not responding. And so they would not cover the expenses.
How much did that result in?
The one doctor's appointment was about $1,200, and I also have medication costs now.
Well, is that covered by your insurance?
The medication, yes, but I still have to pay back the doctor's office for the $1,200. And there's also a back bill from his therapy that was not paid by his father, which was about another $1,200.
When was that from?
I'm not sure. When I re-signed him up for therapy, I was told about it.
Your Honor, in the deviation agreement, the parties agreed that mom would pay 100% of the uninsured health care. I mean, this was negotiated between the parties. And
Why
so,
wouldn't a doctor's appointment be covered by his insurance?
It says you are do 100% of uninsured, basically.
Correct, but this is when he was still under the other insurance, not
All right,
mine.
so why can't you resubmit that, Ms. Jernigan?
well, that's, Your Honor, part of the negotiations was that plaintiff was gonna take over the cost of medical insurance. And that's,
This is January 1.
let's see. Yeah, so if there's any back bills, she can get them to me and we would resubmit them. But as of January 1, yes, she's responsible. That's correct.
Okay, get the back bills to Ms. Jernigan and we'll work on seeing whether it's covered or not.
And then anything under the previous order would be as divided.
Any that's not covered.
Correct. Yeah, and yeah, we would be more than willing to work with that.
Get her the bills, Ms. Wetters.
Okay.
And so then what? Ms.
Well,
I mean, it seems to me like 5 months ago you agreed to this and now you want to change it. And I don't know what the change of circumstance or proper cause, change of circumstance is to change the prior child support order.
well, the fact that he's actually seeing a doctor now, he hadn't seen a doctor in 4 years. He had to, or at least pre-pandemic, I had to get him like 4 or 5 immunizations all at the same doctor's appointment to catch him up.
Well, now, wait a minute. Who had custody of this child before?
Matthew.
What?
Matthew.
Exclusively? What was your time with it?
I had weekends and Wednesdays for the past 4 or 5 years.
And so when you were dealing with this, you had no idea of anything what is going on with your son?
I inquired about his COVID immunizations. I was told that he got them, and I found out that was not correct. And also our previous agreement said that the father had sole decision-making as far as medical treatments goes.
He had sole legal custody?
We share legal, but he had sole physical, basically.
Yeah, that shared legal means you shared all that information. That's what it means. You had as much right to any of that information as he did.
Well, not according to our agreement.
What do you mean? It's
In
all legal.
the agreement, it expressly stated that I was not allowed to make medical decisions, that his father was the only one.
That was in the divorce?
That was in our last agreement when we split the children up.
It's in a court order?
Yep.
Of what date?
I don't know I
All right.
think it was from October of 2020, I want to say. It was when I got custody of Madeline.
All right, Ms. Jernigan, what's your position on this?
Your Honor, the parties have had a long history with the court. The docket's quite long, the report. I don't know of any past orders that I didn't work on. Perhaps my client could speak to that, but it's my understanding the child had the COVID immunizations.
He
And
had one of them. He had one of them, and the Michigan Ticker website does not show anything else. When I brought him to the doctor, he was behind on 4 immunizations of regular ones.
Ms. Jernigan's gonna ask you again, it's your floor to talk.
I would just say if there's any medical bills that need to be addressed, if the plaintiff mom can send those to me, and then we can go from there. I mean, we're not gonna be unreasonable on this issue.
Okay? You just heard that. I think that's appropriate, because I think you just reached an agreement, and I don't think there's any change of circumstances really that you shouldn't or couldn't have known about when you made this decision for the deviation. Otherwise, it just becomes nothing. I enter an order and then turn around and get rid of it. And you're saying, well, I didn't want it or anything to do with the tax exemptions. I don't find that to be very credible. I don't think there's a change of circumstance to review child support, but I do think that all medical bills and whatnot from prior to now, from prior to January 1st, will be exchanged with you. And if they are not taken care of, ma'am, you can renotice this motion, because I'm gonna make him responsible for some type of the prior medical bills and stuff like that. All right, I'm not gonna make you pay those in its entirety. All right, maybe 50%, I don't know, but you're gonna get some help on those. All right, because those were his responsibility at that time. All right, and if his wife was not doing what she was supposed to get him paid, that falls on him. All right, so I'll give you, till 2 weeks from now to get her the medical bills. See if you can reach with something. If you can't, you can renotice this motion, even though it's a child support one. Just send a renotice, send in what's going on with the medical stuff and why I should rule on it.
Okay.
All right?
Appreciate it. Thank you.
I think we sent you an email. I had your email. If you could just please email me or call my office, and we can make sure we get those bills from you.
Yeah.
Okay.
Good luck. Thank you, everybody.
Thank you, Your Honor.